62 starts the original application 2472. Kindly see the challenge. Order dated 9th June 2022. This is the challenge in OA 2472 at page 60, at page 66. Lordship got it? What is 9th June 2022, my lord? Lordship will get at page 61. Kindly see page 61. That is an order by the Deputy Controller. At the very, my lord, at the top it says proceeding under 5.3. And this 9th June 2022, Lieutenant Advocate so-and-so is there. This proceeding has been drawn to adjudicate whether the land over the premise number so-and-so is Thika tenanted or whether the returnee is the Thika tenant. Peruse relevant documents. Appears that Shankar so-and-so has submitted return in phone number so-and-so in respect of premise number so-and-so, 1 Kattha 3 Chetak so-and-so. It revealed that from NSP that the returnee Agarwal is declared as Thika tenant by learned controller on 21st November 2011 in respect of so-and-so. Hence ordered, since the Thika tenant in respect of the aforesaid premises have already been determined, hence there is no scope to further adjudicate the same.
This is not an adjudication as such independently. Relies on the previous one and says that's an adjudication.
Yeah. So he says that I don't have anything further to decide. Already decided.
Right.
So, my lord, the prayer, my lord, kindly sees in this way. What is the prayer at page 78?
Yes, you've seen it.
These are the prayers.
Yes.
Section 12, my lord, of the Thika Act, if I may respectfully invite your lordships.
Yes.
(2001) Thika tenancy. Any person agreed by an order of a controller may, within 30 days from date of order, prefer an appeal in writing before the Land Reforms and Tenancy Tribunal. My lord, in having said up to this, my respectful submission is the lordship has seen, my lord, 61. Lordship has seen page 88. 5.3 was pressed into service. It is not that inherent lack. It is a settled proposition that there are 4 exceptions to invocation of Article 226, despite existence of alternative remedy. Part 3 violation, ultra vires, Lord, an order passed without jurisdiction, and violation of principle of natural justice. Here, my learned senior friend has been saying that this particular order was without jurisdiction. Hence, my lord, availing of alternative remedy is not a stumbling block in invoking the jurisdiction, Article 226. Settled proposition. But here, my respectful submission is not inherent lack. The gentleman had jurisdiction. He has invoked it. May be wrong, may be right. May be wrong, may be right.
So, at the worst, it was an erroneous decision in law.
My lord.
Error of law.
Lord.
Not a jurisdictional error.
No, my lord. He has jurisdiction. He has invoked it.
So, no lack of inherent jurisdiction.
Inherent lack. Exercised it. May be wrong, may be right.
Yes.
So, one of the exceptions carved out, starting from 1998, Whirlpool, up to Godrej Sara, which my learned friend has 2023. So, without jurisdiction, my lord, in my respectful summation, in a pennyworth understanding of the subject, it does not come within that.
Mr. Banerjee has also pointed out, Mr. Galib, that jurisdictional error can be also on a different limb. That is, if the jurisdictional facts, those are not tested, or the jurisdictional parameters to invoke jurisdiction, certain parameters are necessary. Those are not invoked. That is also a jurisdictional error. He particularly relied on non-consideration of, first of all, those that previous one was not a reasoned order at all, he says. Secondly, that it was not taken into consideration as to whether it was a pakka structure with permission. It's a commercial structure. It's not a residential one. So the last few judgments he cited was on that. So these jurisdictional parameters and foundational facts were not considered by the ticket controller. That leads to jurisdictional error. This is one of his submissions, which you say is a legal error.
Lordship. Secondly, my lord, illegal error, my lord. Foundational fact was not taken into consideration while passing the order impugned before the tribunal and also before your lordships, the self-same order under challenge. Foundational facts were not taken into consideration. Hence, it is akin to jurisdictional error. Foundational facts not taken, that is also an error. Can very well be decided.
Well, few of the judgments say that is a jurisdictional error.
No, that is a judicial error. But a jurisdictional error can very well be gone into by the tribunal. Next limb of my argument. Why division bench? My second limb of argument is, my lord, the issue relates to a specified act contemplated under 1997 Act. The concept of honorable division bench to be approached after constitution of a tribunal under Article 323A and 323B of the Constitution comes from L. Chandra Kumar. Otherwise, why division bench? If my learned friend's argument, again, I'm, my lord, reverting back to the earlier position, that 4 exceptions carved out, alternative remedy no bar. You could have gone before, my lord, the single bench on the premise, on the plea that alternative no bar, I have come to challenge because this particular order is without jurisdiction. But today, why the honorable division bench is to be approached? As because there is a constitutional tribunal that is under 323B, LRTT. There are specified acts, the adjudication of which are to be decided by that particular forum of first instance. These are the words used in L. Chandra Kumar, forum of first instance. So, my lord, this without jurisdiction issue, even if I take, assuming admitting, had there not been the existence of tribunal, that could have had been agitated before the honorable single bench.
But as per your submission, even the tribunal should not have jurisdiction because they should have gone up in appeal under Section 12.
Already on appeal.
Oh, Section 12 was filed.
They are on Section 12. These two ways are on Section 12.
No appeal was preferred under Section 12 by them.
Approach before tribunal is under Section 12. All those 2 ways,
right,
are under Section 12. So, my lord, these 4 exceptions, he is on the 4 exceptions. One is without jurisdiction. Alternate remedy no bar. 226 can be invoked. Settled proposition, no quarrel on the issue. But why today honorable division bench? Because there is a tribunal. That tribunal has been constituted under Article 323B. L. Chandra Kumar says that L. Chandra Kumar does not make the tribunal non-existent. L. Chandra Kumar, my lord, said that approach from the tribunal's judgment shall not be directly to Supreme Court. Judicial review, basic structure, inviolable part of the Constitution. Hence, 226 will die judicial review. Now, my next argument, division bench, my lord, of the Honorable High Court in writ jurisdiction is contemplated only for hearing, my lord, clause 15 letter patents appeal. Lordship is not on, my lord, clause 15 letter patents appeal. So, my lord, this jurisdiction today we are addressing before Lordship is because of L. Chandra Kumar. That whatever decision, adjudication comes from tribunal, it has to be before the Honorable Division Bench of High Court. Otherwise, my lord, division bench as contemplated in the Constitution of Chapter 2 of Appellate Side rules. Division bench for writ, I'm not on order 41 or any other, my lord. Division bench for writ is only to hear clause 15 letter patents appeal, mandamus appeal, intra-court appeal. So we are not on clause 15 appeal. Lordship, this chapter 2, Miller Lordship knows, Miller Appellate Side.
Yes, give us a
Chapter 2,
Yes.
Appellate Side rules.
yes.
Kindly see me rule 5A.
No, not a civil litigation. Bandi. Page 18 আছে। Which rule?
Chapter 2, my lord. The chapter is constitution of benches
Or appeals.
and
yes.
powers of the benches and of the registrar.
Chapter 2.
It is 5A, 5, my lord, small a. Clause A. Division bench for the hearing of an appeal under clause 15 from the judgment of a judge sitting singly on the appellate side who has decided an appeal under the first rule of so and so shall consider 2 benches. And latest patent lordship laws. Latest patent kindly see chapter 8. Chapter 8, latest patent.
Yes.
Miller chapter 8, Miller has quoted Miller the clause 15 of latest patent. And it is given in italics, my lord. Kindly says, my lord, that portion, and appeal shall lie to the said high court from a judgment of one judge. So, my lord, division bench, my lord, in the writ side, exercises jurisdiction only in case of, my lord, mandamus appeal or latest patent clause 15 appeal. So, my lord, on the issue of a specified act, indeed, Thika law is a specified act, for which a tribunal has been constituted. It is functional. They have made an approach. So in this, so any issue pertaining to any specified act as contemplated under the 1997 Act, in view of Chandra Kumar, Honorable Division Bench cannot be a forum of first instance. Even if the 4 exceptions carved out with regard to invocation of Article 226, that could have had been, my lord, single bench at the most. My lord, may I place my lord Chandra Kumar? 1997 3 SCC 261. Because my lord, one judgment my learned friend has relied upon, my lord, in my humble understanding,
Justice Indira Banerjee's.
that has given up, my lord, in my, my lord, with deepest of respect, my lord, it has given a part focus on the L. Chandra Kumar. 97. Yes. 3 SCC 261. May I, my lord, respectfully invite your lordship to certain paragraphs of this particular judgment.
Yes. Give us the paragraphs if you have a note, then we just take a note and then go into.
My lord, the issues there will be in paragraph 1.
Yes. What are the paragraphs you are relying on total?
And 90, from 90 to 93.
All right.
From 90 to 93. 94 also, my lord, and 99. Lordship will make a quick reading, but my lord,
Yes.
kindly see the issues, my lord. The specially petition civil appeals writ petition so and so together constitute. They have, however, been grouped together as all of them involve the constitution of following broad issues. 1. Whether the power conferred upon Parliament or the state legislature, as the case may be, by subclause D of clause 2 of Article 323A, or by subclause D or subclause 3 of 323B. My lord, may I pause for a moment? In that division bench judgment of CLT, they said that L. Chandra Kumar was only on Administrative Tribunal Act. No. Chandra Kumar was dealing with entire spectrum of tribunalization as contemplated under 323A and 323B. What will be the fate of all those litigants who, my lord, get an adjudication from these tribunals, constitutional tribunals? These are constitutional tribunals. My lord, kindly says, my lord, where the power conferred upon Parliament or state so and so, subclause D of clause D of 323A or subclause D of clause D of 323B of the Constitution to totally exclude the jurisdiction of all courts except that of Supreme Court on Article 136 in respect of disputes and complaints referred to in clause 1 of 323A, or with regard to all or any of the matters present in clause 2 of 323B, runs counter to the past judicial review conferred on the high courts on Article 226 to 227 and on the Supreme Court under 32 of the Constitution. Second major issue is whether the tribunal constituted either under 323A or 323B of the Constitution possesses the competence to test the constitutional validity of statutory provision rule. 3. Whether the tribunals as they are functioning at present can be said to be effective substitutes for high courts in discharging the past judicial review. If not, what are the changes required to make them conform to their founding objectives? Similar, now may I respectfully invite your lordship to straight to page 90. The observation starts from page 50, para 50. Observations start from para 50. My lord, may I read out, my lord, from para 90 to 93, my lord. We may first address the issue of exclusion of power of judicial review of the high courts. We have already held that in respect of the power of judicial review, the jurisdiction of high court under 226, 227 cannot wholly be excluded. It has been contended before us that the tribunal should not be allowed to adjudicate upon matters where the iris of the legislation is questioned, and that they should restrict themselves to handling matters where the constitutional issues are not raised. We cannot bring ourselves to agree to this proposition, as that may result in splitting up proceedings and may cause avoidable delay. If such a view were to be adopted, it would be open for litigants to raise constitutional issues, many of which may be quite frivolous, to directly approach the high courts and thus subvert the jurisdiction of the tribunals. Moreover, even in these special branches of law, some areas do involve the constitutional question on a regular basis. For instance, service law matter, a large majority of cases involving interpretation of Article 14, 15, and 16. To hold that tribunals have no power to handle matters involving constitutional issues would not serve the purpose for which they were constituted. On the other hand, to hold that all such decisions will be subject to the jurisdiction of the High Court under Article 226, 227 of the Constitution before a division bench of the High Court within whose territorial jurisdiction the tribunal concerned falls will serve two purposes. While saving the power of judicial review or legislative action vested in the High Courts under Article 226, 227 of the Constitution, it will ensure that frivolous claims are filtered out through the process of adjudication in the tribunal. The High Court will also have the benefit of a reasoned decision on merits, which will be of use in its. My lord, may I, my lord, pause for a moment. Your lordship will find this decision. There has to be a decision by the tribunal so that Honorable Division Bench High Court can sit over a filtered views of an adjudicating authority. Decision has to be there on merits. In many subsequent judgments, I find interpretation, no decision needed. So, Milord L. Chandrakumar has Milord, was very much protective of tribunals. Now, kindly sees 90. It has also been contended before us that even in dealing with cases which are properly before the tribunals, the manner in which justice is dispensed by them leaves much to be desired. Moreover, the remedy provided in the parent statutes by way of an appeal by special leave under 136 is too costly and inaccessible for it to be real and effective. Furthermore, the result of providing such a remedy is that the docket of the Supreme Court is crowded with decision of tribunals that are challenged on relatively trivial grounds and is forced to perform the role of the first appellate court. We have already emphasized the necessity for ensuring that the high courts are able to exercise judicial superintendence over the decisions of the tribunal under Article 226 in the Constitution. In R.K. Jain, after taking notes of these facts, it was suggested that the possibility of an appeal from the tribunal on question of law to a division bench, within whose territorial jurisdiction the tribunal falls, be pursued. It appears that no follow-up action has been taken pursuant to suggestion. Such a measure would have improved matters considerably. Having regard to both the aforesaid contentions, we hold that all decisions of tribunals, whether created pursuant to 323A or 323B of the Constitution, will be subject to High Court's jurisdiction under Article 226, 227 before a division bench of the High Court, within whose jurisdiction a particular tribunal falls. So there has to be an adjudication decision and there has to be a division bench too. May I kindly say 92, Milord. We may add here that under the existing system, direct appeals have been provided from the decisions of all tribunals of Supreme Court authorities. In view of our observation, this situation will stand modified. In view, we have taken no appeal from decision. Again, decision of the will directly lie before the Supreme Court under Article 30. But instead, the aggrieved party will be entitled to move to High Court under Article 226, 227, and from the decision of the division bench of the High Court, the aggrieved party. Decision is the Miller clarion call of the entire judgment. 93, Miller kindly says, before moving on to other aspects, we may summarize our conclusion on the jurisdictional powers of these tribunals. The tribunals are accompanied to hear matters where the virus of statutory provisions are questioned. So even the virus of all these by which they are being created, when they can. Only the virus of the act by which they took birth.
Own constitution.
Yes. The virus of the birth certificate, they cannot. Except that they can. However, in discharging his duty, they cannot act as substitutes. They cannot act as substitutes for the High Court and the Supreme Court, which have under our constitutional setup been specifically entrusted with such an obligation. Their functions in this respect is only supplementary. And all such decisions of the tribunal shall be subject to scrutiny before a division bench of the respective high courts. Tribunal will consequently also have the power to test the virus of subordinate legislation rules. However, this power of tribunal will be subject to one important exception. The tribunal shall not enter any question regarding virus of their parent statute, followed by settled principle that tribunal is a creature so and so. Then all other decisions of these tribunals rendered in cases that they are specifically empowered to adjudicate upon by virtue of the parent statute will also be subject to scrutiny before the division bench of the respective high court. We may add the tribunal will, however, continue to act as only courts of first instance. This phrase we use in our submission, borrowing from this particular forum of first instance of the areas of law that is specified acts as per 1997, for which they have been constituted. By this we mean that it will not be open for litigants to directly approach the high courts, even in cases where they question the virus of statute legislation, except that by overlooking the jurisdiction of the tribunal concerned. In virus also, we are not saying that virus directly high court. No, you can go over there and challenge it. So particular observation. Now 94, Milord. Kindly say directions issued by us in respect of making the decisions of tribunals amenable to scrutiny before division bench or respective high court will, however, come into effect prospectively so and so. Now, Milord, 99. Para 99, Milord, if I may, Milord, read out, Milord. In view of the reasoning adopted by us, we hold that clause 2D of Article 323A and 3D of Article 323B. So both articles were taken care of. To the extent they exclude the jurisdiction of high courts and the Supreme Court, Article 220 and 32 are unconstitutional. Section 28 of the Act. This Act means it is referring to Administrative Tribunal Act. This Act 28 exclusion jurisdiction clause in all other registrations under the aegis of 323 and 320 would to the same extent be unconstitutional. Jurisdiction conferred upon the High Courts under Article 227 upon High Court of the is inviolable basic structure of Constitution. While this jurisdiction cannot be ousted, other courts and tribunals may perform a supplemental role in discharging the powers conferred by Article 220, 227 and 32. So they are playing supplemental role.
Yes.
So the tribunals created in Article 323, 3D of the are possessed of the competence to test the constitutional validity of statutory provisions. All decisions of this type, so there has to decisions of the tribunal will however be subject to scrutiny before the division bench of the High Court within whose jurisdiction the tribunal falls. The tribunals will nevertheless continue to act like courts of again first instance, court of first instance in respect of the areas of law for which they have been constituted. It will not therefore be open for litigants to directly approach the high courts, even in cases where they question the values of statute legislations by overlooking the jurisdiction of the tribunal concerned. Section 5.6 is valid and constitutional, that is 5.6 of India. So kindly say 100. All these matters may now be listed before the division bench to enable them to be decided upon the individual facts in light of the solos. So, my lord, my respectful submission after going through this paragraph said, one thing is the foundation of this judgment is there has to be a decision of the tribunal, and that is on merit, which will be subject to scrutiny, of course, by the Honorable Division Bench. So, this concept of division bench comes because L. Chandrakumar has made Miller Tribunal, this constitutional tribunal, as a forum of first instance. They will have to adjudicate on merit. So the Honorable Division will get the opportunity of going through a filtered decision. So, my lord, giving a goba in the name of writ of certiorari, they can, my lord. Since they have taken recourse to it, they can. Let there be a filtered decision. Merit. And if they're so anxious that yes, there is dilly-dallying this and that, then my lord, that taking benefit of that exception, one of the exceptions, they could approach the single bench. They see alternative remedy, no bar. This judgment, this order of the controller is without jurisdiction. I have invoked 220C directly. Because division bench from a specified act is because of this L. Chandrakumar. Otherwise, clause 15 in writ jurisdiction, there cannot be division when you read other than clause 15 appeal. Having said so, my lord. Yes, my lord. Subsequent judgment, even after tribunalization, there are two incidents where, despite, my lord, the issues pertaining to the specified acts. No, my lord. No, after the, my lord, before cruising on to the next leg of argument, my lord, may I, my lord, take your lordship, my lord, respectfully, my lord, to the 1997 Act. At the back of LR Act.
157 is it?
LR Act.
Yes.
My lord, this 1997 Acts, my lord, Act, my lord. Kindly see, may I show your lordship the SOR, my lord, or the preamble to the Act, my lord. My lord, this Act has come in the year into operant 1997.
December. Chandrakumar was March.
Yes, after that. That's why lordship will get the echo of these words in the preamble to the Act.
Borrowed from Chandrakumar.
Lordship, all these.
So should be read in the light of L. Chandrakumar.
Yes.
That is your.
Yes. The preamble is borrowing all the words from there. That is why I was willing to, my lord, reach the preamble of that to the act. So lordship finds this. Then, my lord, judgment in 2016 CLT, it has covered. So specified act, lordship knows, my lord, very thorough now, my lord. That is section 2, my lord. Section 2, my lord, clause R, my lord. Specify what are the specified acts. So Thika is one of the specified acts. Lordship is by now is already thorough with all this issue. And, my lord, lordship will find that my learned senior friend has been referring to this 2016 3 CLT judgment division bench. CLT judgment, lordship will find that it has taken note of 7 and 8, section 7 and 8. But why not section 11? No appeal or application against any decision of the tribunal in the proceeding shall lie to any court except Supreme Court under Article 226, 227. Why I mention this? Here also says decision of the tribunal. And it is appeal. In a way, my lord, in my humble understanding, I may say it is a one-way step forward than that of L. Chandra Kumar, because L. Chandra Kumar says it is a judicial review of the decision of the tribunal. But here, section 11 gives power of appeal. Judicial review is not appeal in disguise. So, my lord, here it also says decision. Decision is on merit. That has been said by L. Chandra Kumar. Next, my lord, may I, my lord? My respectful submission, my lord, in my pennyworth understanding of the issue, my lord, is, my lord, that yes, there are two situations visualized or contemplated under which, despite the issues being covered by the specified acts after tribunalization under Article 323 and 323B, yes, you can make a direct approach in respect of those subjects, but before the single bench, under two circumstances. One judgment says, under a very, it uses the word twice, very exceptional circumstances, where invoking ESMA, mass layoff was made in Tamil Nadu. So there, Honorable Supreme Court head, it's a very exceptional circumstances.
And where the tribunal is not functioning also.
One man. So that is very, and second is when it is dysfunctional. A very recent division bench judgment of our High Court that since SAT is totally dysfunctional, so it has requested the
umpteen judgments.
So recently, it is a recent development because all are coming directly here before the division bench. So division bench, lordship, then some came before the single bench. So one single bench judgment went up to before division bench. Division bench said no, it will be before single bench. So it is dysfunctional. So two situations contemplated, very and dysfunctional. May I place those two judgments, my lord? Only for assistance, my lord, my lord. 2003-6, my lord. SCC, my lord, 581. My lord, kindly see the issues. (585), my lord, kindly straight away come to, my lord. Kindly. Para 2 is the issue. Unprecedented action of Tamil Nadu government terminating the service of all the employees who have resorted to strike for their demands was challenged before the High Court by filing writ petition under Article 226. Learned single bench by an interim order directed the state government the suspension and dismissal of a without conducting inquiry be kept in abeyance. Next page, my lord. Now state went for appeal, division bench. Division bench also deprecated. Now this went up before Supreme under Article 32. Thereafter, 32. Simultaneous. Apart from that challenge, No, 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 no. The order is challenged by filing these appeals. Division bench order was appealed. Were also filed. In addition to that, what does it say, Miller? Kindly sees. Paragraph 9 and 10. These two paragraphs I'll be showing your lordships. The Supreme Court entertained it. Yes, the single bench was correct in entertaining. It said 9. It said thereafter the court, to emphasize the administrative tribunal are not functioning. This para 9, the court has quoted, Milord, paragraph 88 of L. Chandra Kumar. This quote is para 88 of L. Chandra Kumar. Then at the bottom, Miller kindly sees one line. It is to be stated that in Tamil Nadu, lordship got this point. At present, the tribunal is banned by only one man. So that was the present situation then. Then comes to 10, Miller, if I may respectfully invite your lordship too. There cannot be any doubt that the aforesaid judgment of larger bench is binding on this court. Larger means they are referring to L. Chandra Kumar. And we respectfully agree with the same. However, in a case like this, if thousands of employees are directed to approach the administrative the tribunal would not be in a position to render justice to the cause. He has stated earlier because of very, very exceptional circumstances that arose in the present case, there was no justified reason for the High Court not to entertain the petitions on the ground of alternate remedy. So here approach was made before the single bench, single to division, division to High Supreme Court. In that circumstances, Supreme Court, yes, very, very exceptional. Single bench approach was good. Single bench approach was good. Single bench should have had entertained. Why? Because it is manned by one man and very, very exceptional circumstances. Now, Miller Roser Matthew, Miller 20, volume 6, SCC 1. Miller, kindly pardon me, Miller, to pardon your lordship with this, Miller. But only for one paragraph.
2020 SCC.
2026 SCC 1. Here, my lord.
Mr. Gali will come back and resume.
Lordship.
Which paragraph, Mr. Galib?
Milord, Roger Matthew Milord, 2026 SCC, page 1, Milord. May I, Milord, straight away, Milord, invite your lordship to paragraph 392. Here, Milord, the issue was, Milord, they were asking for implementation of certain, Milord, directions given in L. Chandra Kumar as well as Madras Bar Association High Court judgment. So, Milord, while dealing with this issue, Milord, it's a 5-judgment judgment,
Yes.
Roger Matthew. So, kindly see, Milord, what does it say, Milord, in para, Milord, 392. The litigants cannot wait for judicial impact assessment. An action by the government, which may or may not take place. Experience has shown that the judgments right from L. Chandra Kumar to Madras Bar Association have not been complied with the union in letter and spirit. Citizens of this country cannot be denied justice, which is the first promise made in the preamble. Therefore, I am of the view, this is the view, Milord, which Justice Deepak Gupta, Milord, is supplementing, starting from paragraph 231. From para 231, Justice Gupta, Milord, is supplementing his views, concurring, but supplementing his views. From 230, Lord, you will get it. So that's why he's I am of the view. Therefore, I am of the view that in whichever state union territory the bench of a particular premise not established or functioning, the litigants of that state will have a right to invoke the extraordinary jurisdiction of that state under Article 226 for redressal of their grievance. They cannot be expected to go too far off distant and spend huge. A travel is an illusory remedy and not an efficacious alternative remedy. So, Milord, this is the circumstance when direct approach. But direct approach, Milord, cannot by overriding L. Chandra Kumar's concept. It is single bench. As is clear from 2003-6.
Yes.
Milord, 1920, on the proposition judicial review from, again, decision of the tribunal. That has to be a decision of the tribunal. This is a proposition of this particular judgment. I am willing to cite it. 1920, 2019, Milord, 20 SCC,
2019.
143.
Yes. But Justice Banerjee was also part.
Yes. Milord, paras 84 to 87 kindly see, Milord.
84 to 87.
84 to 87. Here in para 85, Lordship will find, it says, it is not an appeal in disguise. So if your Lordship reads this paragraph, juxtapose section 11 of the 1997 Act, it says it appeal from the decision. Para 86 kindly sees, in exercise of his extraordinary power of superintendence, the High Court's restrict interference to case of patent error of law which go to the root of the decision, perversity, arbitrariness, or unreasonableness, violation of natural justice, lack of jurisdiction. High Court does not reassess or reanalyze the evidence of materials on record. The High Court will control its jurisdiction to test a decision of rate control, so and so. L. Chandra Kumar, Supreme Court 87, Milord, held that power of High Court 226. So again, in Chandra Kumar, Milord, it says kindly sees, L. Chandra Kumar cannot be constituted to enlarge the jurisdiction of the High Court under Article 2 to enable its appellate powers. So, Milord, Lordship, Milord, the line of decision, Milord, I have been relying upon stating, Milord, decision is, Milord, is sine qua non. There has to be a decision to come before a division bench. Since there is a tribunal and specified acts to be decided by a tribunal. What is the decision? Supreme Court has said in one of the judgments. What is the decision, Milord? My lord, may I prefer to, my lord, to cite this judgment, my lord, at a cost of castigation?
Here there is no question of Mr. Galib.
My lord,
You're relying on that is an irrelevant factor here.
yes.
There has been no decision by the tribunal.
Lordship.
This is the
And
question
no
of-
tribunal order has also been under challenge.
Yes.
Here, whatever prayer made in section 12 appeal before the way.
It was a case where the tribunal has made a cryptic order or something like that, where it's in question whether it's a decision at all. Then this judgment would be relevant. Here
Lordship.
there is no decision of the tribunal.
No, my lord thrust of argument is this, that in order to approach the honorable division bench, in this
Decision, your trust is not on decision of the tribunal, as
Tri-
great as it.
has to be direct, my lord, approach, my lord, invoking, my lord, deed of certiorari in respect of a specified act cannot be.
Okay.
There has to be a decision of the tribunal. Otherwise, they could have very much, my lord, approached the single bench saying that, see, controller is an Article 12 authority. This particular order comes within one of the exceptions carved out in Whirlpool and this, so without jurisdiction taken.
Get your point.
Lordship.
So that's all.
The Article 12 authority.
Yes.
But here, section 12 of my lord Thika law says appeal has to be before the tribunal. Which tribunal? 323, Constitutional 323B. Next, my lord.
How many more?
No, there is no next, lordship.
Concluding.
So there's dysfunctional tribunal, lordship, that's division bench judgment, my lord. So only on these circumstances.
Very,
they
very
can approach.
exceptional, dysfunctional.
Lordship. So, my lord, now distinguishing his judgments, my lord.
Yes. You have distinguished.
I have.
Shy enclaves is the main judgment on this.
Yes,
The other judgments primarily on merits.
my lord.
And
So-
yes, this.
And
Yes.
here, my lord, the issue was the 5-3 proceeding before controller was pending. An inquiry was ordered, then challenge was made before the tribunal. That see, he does not have the power to carry on the inquiry, the direct inquiry under 5-3, section 5-3 Thika law. So that was pending. And here, my lord, the 5-3 proceeding has been completed. Maybe wrong, maybe right. Here, my lord, it is clear from this judgment. Para 43 issue in writ. Para 43 of the Shy enclave. And their affidavit was also in exchange the writ petition, I find, from para 79. Hitting on the point of jurisdiction, without jurisdiction, that is the only exception, my lord, they are taking benefit of the without jurisdiction. And only one, my lord, that my lord, this L. Chandra Kumar has not been given proper justice in my humble understanding in this particular judgment, lordship. Because it says that para 136, lordship will kindly find, my lord. It is well settled, para 136. It will well settle that judgment is a precedent for the issue of law what is raised and decided. The judgment of constitutional bench in Chandra Kumar was rendered in relation to the Administrative Tribunal Act. It is, my lord, it is not only 323A. Administrative Tribunal is 323A. But all these tribunals are 323B. So 323B also have been touched upon. Well, this is, my lord, very, my lord, with a casual approach, my lord, that lordship. So in this way, my lord,
Yes, so let us take up other matters. Yes. That is over.
lordship.
Yes, Mr. Banerjee, what reply? No reply.
Just only on these
Put
judgments.
it in written notes about this.
My lord, only one judgment, may I, my lord, cite only one
On what proposition?
certiorari vis-a-vis the tribunal. Certiorari always we pray before a
Relevant,
single
relevant,
bench.
right.
Always we pray before single bench. The certiorari vis-a-vis minute where there is a tribunal subject.
Understood.
My lord, 1954. Para 6, my lord, kindly sees first.
এটা বললেন না, সাইটেশনটা পুরো বললেন।
Oh, acha. 1954 to SCC 881. It's a 7-judgment judgment. It also arose from a tribunal, election tribunal. So whether 226 para 6 is the question. Kindly see, my lord, page thereafter 23. 23 Placita, my lord, F and G, kindly seize, my lord. It may also be noted that while in a certiorari under Article 226 can only annul the decision of the tribunal. So this is a certiorari vis-a-vis tribunal. Annul the decision of a tribunal, it can under Article 2 do that and also can issue further direction in the matter. This is what it says. We must accordingly hold that application of the appellant for other is maintenance. So this is what?
No. We were wondering whether there is any judgment to say that
Now paragraph 20.
tribunal can exercise certiorari.
Yes.
Normal powers of calling for the records
Quashing,
is always there.
in principle.
Quashing, calling for the records, looking into the records, correcting the records.
So
these are
in
there.
principle, they are exercising supplemental role of the single bench.
So why are you citing this judgment?
No, because, my lord, it is vis-a-vis tribunal.
Yes.
Vis-a-vis the tribunal. My
So
lord,
just because this judgment says that certiorari can be issued vis-a-vis tribunal does not mean certiorari cannot be issued but vis-a-vis others. No, the converse is not true.
no, it is okay.
This judgment is irrelevant.
Or my lord, division bench, my lord,
Certiorari can definitely be issued in respect of tribunal.
it can, my lord.
What are you trying to
No,
prove?
I am trying to point out, my lord, here there should have been a decision.
No, certiorari that does not require a decision per se.
No, but in respect,
Certiorari does not require a decision per se.
no, as because
Certiorari for quashing also we can take up. We can invoke certiorari. It's a high prerogative writ. We can, whenever we find there is any abuse or something, some sort of procedural infirmity of a high order, we can definitely exercise our certiorari power.
lordship can do it.
No decision is required for certiorari.
No, no, I'm not on that. I am on
For the
issue,
record, we
my
can
lord.
call for the records. We can
Since
correct the records.
since the, my lord, the specified act is, my lord, class is within
Why are
the,
you citing? What is the point?
as because kindly sees, my lord,
This says that 227, under 226, 227, High Court can
And
issue under 226 certiorari can be issued against tribunal, and 227 further direction can be given.
my lord,
So,
I am citing this for the reason
yes,
in a matter where the subject, my lord, is, my lord, included in the tribunal, specified act of a tribunal constituted under Article 323A, 323AB,
yes.
the approach before the division bench can be done only, my lord, for quashing the decision of the tribunal by invoking certiorari, not the, my lord, certiorari for quashing the judgment of the authority concerned.
This does not say that. This only says that certiorari can be invoked by the High Court against tribunal. Does not say it cannot be invoked against others, which definitely can be.
It can be, my lord, but here
This does not say that.
but
Lay down that.
my lord, hence, my lord, my entire argument hinges upon the fact, since here, my lord, the subject is covered by specified act.
That for that you have already cited.
Yes, my lord. So, my lord, direct approach before honorable division bench, my lord.
Yes. No further judgment is necessary for that.
Lordship.
Yes, Mr. Banerjee, very short, 2 minutes.
Yes, just only on the judgments that he has cited. L. Chandra Kumar, my lord, it might take slightly more than 2 minutes, 2.5 minutes maybe. L. Chandra Kumar, my lord, 1997, 3 SCC 261, paragraphs 1, 90, 93, 94, and 99. L. Chandra Kumar's situation was a situation in which, by the Administrative Tribunals Act, the direct appeal lay from an order passed by the tribunal to the Supreme Court. L. Chandra Kumar had occasion to examine whether the basic structure includes 226 and 227, and therefore whether they can be excluded from the scheme of things under a statute. L. Chandra Kumar said that cannot be done, but said that in order to maintain a hierarchy of fora, what we do is we say that a division, the tribunal will
Tribunal division bench.
and then High Court. That was L. Chandra Kumar reading down the Administrative Tribunals Act and saying that this should therefore be the policy followed in respect of other similar acts made under 323A and 323B.
Issues formulated in para 1 does not say that it is confined to Administrative Tribunal Act.
Yes, no. 323A and 323B, but when the legislature will enact a law, under 323A or 323B, it will keep in mind this formulation. That is not the L. Chandra Kumar. Legislature enacted a law, West Bengal Land Reforms and Tenancy Tribunal Act 1997. After L.
After L. Chandra Kumar.
Therefore, legislature has captured the spirit of L. Chandra Kumar to that extent that it has kept the division bench as the bench strength before which you can come to High Court. Kindly come to 8 and 11 again.
Sin, remember.
Bench strength. So that is the only requirement which L. Chandra Kumar had. Legislature has never said, could not have, number one, said that you can't come to the High Court under 226. That provision would auto implode. Second, legislature has never said, even in the act, that one needs to bounce it off a tribunal in order to come to Article 226. That has not been said in the act. So there is no statutory bar. L. Chandra Kumar did not consider a situation in which whether its formulation made the High Court approach direct, completely impossible in case of a want of jurisdiction. All these are discussions regarding decisions or orders taken within jurisdiction. If there is a want of jurisdiction, whether inherent or subsequent because of stepping out, want of jurisdiction cases are exclusively addressable under certiorari as the first recourse. If there is no decision, certiorari. Even if there is a decision tainted by want of jurisdiction, certiorari. And this is something which the tribunal may not be in a position to give. Please have a look at the tribunal's powers under 6 and 10. Any order or decision of an authority, please see, Lord, section 6, section 10. Then I'll show you, Lordship, Lord, section 12 of the Tenancy Act also. Please come, Lord, to the West Bengal Land Reforms Tenancy Tribunal Act, section 6. Rules are please see, Lord, paragraph section 6A. B is culpable negligence or inaction. A. Others are absolutely specified. Now, my humble submission is, if an order or if a proceeding or an order suffers from lack of jurisdiction, it no longer becomes an order made by an authority under the specified act.
What about D?
Applications relating to matters under any provision of a specified act or matters relating to the constitutional validity of any act under the provisions of a specified act. Applications relating to matters under any provision of a specified act. This would once again consider intra vires matters. Otherwise, certiorari goes out of the book. Certiorari is a panacea for ultra vires.
We'll change the stress. Applications relating to matters under any provision of a specified act.
You have had access to come to the tribunal. Kindly with this, read 8.
Application relating to matters under any provision of a specified act of matters. So where was that application?
And please see 7 also.
Yes, 7.
7 is very important.
Exercise by tribunal of jurisdiction, power and authority exercisable by court. Save as otherwise expressly provided in the act, the tribunal shall, with effect from the date appointed by the state government under section 6,
Forget that. The next.
exercise all the jurisdiction, power and authority exercisable immediately before that day by any court, including the High Court. Now, my lord, kindly see. Including the High Court, except the writ jurisdiction under Articles 226 and 227 to be of the Constitution exercised by a division bench of the High Court, but excluding the Supreme Court for adjudication or trial. Here again, the wide expanse.
Single bench can exercise certiorari. That is not excluded.
My lord.
Single bench of High Court can exercise certiorari. That has been conferred on the tribunal. Save as expressly provided, the tribunal shall, with effect from the date appointed by whatever, exercise all the jurisdiction, power and authority exercisable immediately before that day by any court, including the High Court, except division bench power.
Except the writ jurisdiction under Article 226.
Except writ jurisdiction, Article 226.
Under Article 226
No,
and 226.
exercised by a division bench. But prior to that, including the High Court has been given, and except jurisdiction under 226, 227 is qualified by exercised by a division bench.
This takes care of matters in which there are statutory appeals before High Court. There are very many matters in which there are statutory appeals before High Court.
This is one of such acts.
No statutory appeal before High Court.
No,
No
the
statutory
challenge
appeal
lies against the by L. Chandra Kumar, by dint of L. Chandra Kumar, we exercise power in division bench against tribunal orders.
Against tribunal orders or in connection with matters related to tribunal. Not would your lordship kindly seize, my lord?
Tribunal, why do you say tribunal does not have the power of certiorari?
According to me, my lord,
7 read with 6D confers that power.
my lord,
It's very clear.
my lord, in my reciprocal submission,
Yes.
the question would be whether the tribunal having the power makes it a substitute for the High Court under Article 226. The
Substitute for the single judge. L. Chandra Kumar says that. Division bench is only exception. L.
substitute
Chandra
for
Kumar is very clear.
Yes.
Substitute.
yes.
All powers exercisable by High Court except division bench can be exercised under 6D, any matters relating to any specified act. L. Chandra Kumar says yes, decision of, as Mr. Gali pointed out, decision of tribunal can be challenged before division bench. You see, we don't have, in our determination also, if you see, Mr. Banerjee, no division bench of this court has been conferred vested with any power to entertain an Article 226 application or a writ petition against any order of the tribunal under 323 AB. It's only division benches which have been conferred that power.
Yes,
It has been
that's
recognized
because
judicially,
of L. Chandra Kumar.
administratively, everywhere.
Now the question, Lord, would only be this.
If we function as a writ court, no division bench of this court today has determination to function as a writ court, original writ court, 226, barring tribunal applications under 323A and B.
Now here, if there is scope for the division bench here to exercise 226 as a bench of original jurisdiction, does this equation in the statute take away that right? That is what I am, my lord, humbly submitting. There's a difference between the two, slim but palpable. Does it take away the right of certiorari from the lordships?
You will be then you're banging your head against a high court which does not have any division bench which has this power. No division bench has determination to hear these matters. Then your matter won't be heard by any division bench of this court. None of us have determination. Chief is the master of the roster.
No, but
So in any event,
as far as jurisdiction of your lordships to take up Article 226 matters are concerned in the division bench, a la 323A or 323B is concerned, that would be the subject matter relating to the specified acts. But once that subject matter is there in its widest
Yes.
amplitude,
yes.
my lords can take up that matter. My lords can take up that matter for exercise of original jurisdiction of certiorari. What I am submitting is this: the jurisdiction of certiorari of your lordships as the High Court is a basic feature which cannot be taken away, my lord, by the Tribunals Act, was never sought to be taken away by L. Chandra Kumar. L. Chandra Kumar merely made your lordships exercise that power.
Very good. So let us stop there. What else?
Just two
Yes.
more.
This will go on.
Supplementary.
No, that supplemental part, can I show you lordship from L. Chandra Kumar? Para 93.
It assumes that there is an original
Supplemental part?
The jurisdiction. L. Chandra Kumar, just once.
We have the entire paragraph has been read, Mr. Banerjee. You have nothing else to show us.
Just
We'll have to interpret that now.
now, my lord, my humble
We have
submission,
seen need not read the same paragraph over and over again.
my humble submission is only this. The proposition being sought to be advanced is this: my lords sitting in the Honorable High Court, being a division bench, would not have the jurisdiction to touch a matter arising out of the specified acts unless it is preceded by a decision of the tribunal on that matter. That's the argument being sought to be advanced. In my respectful submission, tribunalization by virtue of the West Bengal Land Reforms and Tenancy Tribunal Act does not take away the original jurisdiction of the High Court under Article 226 of the Constitution of India. That's L. Chandra Kumar. That's also Section 8 of the Parent Act.
Yes.
It does not take away. If it does not take away, who will exercise it? That's the question. Will it be exercised by a single judge having determination under Group 1 matters as land laws? Or will it be taken or exercised by a division bench which is sitting in connection with matters arising out of tribunals. In my reciprocal submission, it will be the latter because of two things. Number one, the formulation in the act that only the division bench can exercise 226. Act, please see, my lord, section 7.
Seen that?
Writ jurisdiction under articles 226 and 227.
Yes.
So my humble submission is, by tribunalization, this original jurisdiction has not been curtailed. My lords,
Said that ad nauseum. You have argued that ad nauseum, Mr. Banerjee. Why repeat on and on and on and on and on?
no,
You have said that from yesterday. You have been saying that.
so my lord,
What do you?
only on that. Now, as far as, my lord, the Rent Control Act is concerned, it made the same mistake. Now, 2019 20 SCC 143, which was cited, Justice Indira Banerjee's judgment, my lord. That was a case in which the same folly as as L. Chandrakumar had been made in connection with a state Rent Control Act. There in section 12, it had been held that from a decision of the Rent Control Tribunal, an appeal would lie directly to the Supreme Court.
In
Therefore,
that context, it was held
in
that.
that context, it was held that. So this is that's Justice Banerjee's judgment. Now, my lord, coming to 2003 6 SCC 581 paragraphs 9 and 10, where the Tamil Nadu government and that arose, my lord, in a different situation. May I take your lordship only through that? Please give me just 30 more seconds after 2000.
We think para 2, 9 and 10 sum up the issue.
Yes.
As Mr. Galib rightly pointed.
Now, as far as paragraph 2 is concerned, may I just show you, lordship, lord, what was before, my lord, the tribunal?
We have seen that. It has
Para 4.
4. Yes. What is that order is challenged by Farid?
For the same reliefs, writ petitions under Article 32 are also filed. So when the Honorable Supreme Court considered these matters, the Honorable Supreme Court was considering original challenges made in its 32 jurisdiction along with SLPs arising out of those orders. And when the Supreme Court ultimately makes whatever observations it has had to make, the Honorable Supreme Court doesn't compartmentalize in which particular proceeding these observations have been made. Please come to paragraph 26 and 27. Appeals and writ petitions are disposed of accordingly. So in my reciprocal submission, these observations do not militate against the decision of the Honorable Division Bench, which I had placed.
Probably you are not correct. Please come to para 10. That answers your query. It was not in the context of the original appeals. It was in the context of the other challenge. Please read para 10. Mr. Galib has read that. But for your satisfaction, please read it.
Yes. There cannot be any doubt that the aforesaid judgment of the larger bench is binding on this court, and we respectfully agree with the same. However, in a case like this, if thousands of employees are directed to approach the administrative tribunal, the tribunal would not be in a position to render justice to the cause. Hence, as stated earlier, because of very, very exceptional circumstance that arose in the present case, there was no justifiable reason for the High Court not to entertain the petitions.
The High Court not to entertain. That was the context. And Mr. Galib relies on para 10 only.
Yes, yes. So that
was in the context clearly of the High Court only.
Clearly of the High Court.
Para 10 is clearly on the High Court.
And jurisdiction of the High Court under Article 226, my lord, was upheld.
Say, thousands of people cannot be relegated to the administrative tribunal.
Therefore,
although that reason is not very clear to us, but that's our limitation. Since the Supreme Court says that is law.
So the point is, my lord's jurisdiction under Article 226 remains. It's not shaved, taken away, cut by by
all the three are synonyms. Don't multiply words.
Sorry. By Article 226.
Banerjee, we have heard you enough. Yes. You file a written notes of arguments on the next day. When can you file it?
Well, give us
we won't give you much time so that it's brief. No, but make it brief. It should not be like the arguments.
Next Monday.
Maybe a weekend in between.
Okay. We'll keep it when? Monday?
Anytime. And I'm also making the submission that in the event my lords are of the view that my lords
Hmm.
would not have determination
Hmm.
because of the specific jurisdiction given to your lordships, that may not.
Determination does not govern. We say that as an indication.
No, I mean, I say that.
The determination, if you otherwise inherently have jurisdiction, if any other bench has been given that determination,
then
there is some doubt. We express doubt in our judgment, but there was a challenge against that. I expressed in single bench a doubt regarding that, even if a particular bench. But I also raised it as a reference frame. That reference has been answered against my view. It has been now held categorically by Justice Boshak's bench, larger bench, that no, if a determination is not given to a particular bench, it's a nullity if that bench passes. The other view was, my view was that no, it's not a nullity. If there is no inherent lack of jurisdiction, that was turned. Now it has been settled by our High Court larger bench that it's a nullity if a bench. But this is not such a case. You have a point there. Determination was only, our reference to determination was only as an indication that this power is not there. But determination does not, if no bench has determination, if any other bench had determination, our judgment would be a nullity. If no bench in the High Court has determination,
then the High
we
Court
might be having a leeway to carve out a determination within this. There is sufficient space in the language to carve that out.
Only that it is.
That's only an indication.
Land Revenue Tribunal, it should be Land Reforms Tribunal. That's the only difficulty. It appears as revenue everywhere, even in the list.
Yes.
Grateful to Lordship. But there is no Land Revenue Tribunal under 323 and 323.
No.
So
Here, oral arguments are concluded. Full stop. The matter shall be listed under the heading to be mentioned on April 6, 2026 for the purpose of filing of written notes of arguments by the parties respectively. Thank you very much.
Please.
Yes.
You already taken notes.
No. I'll a short written note so that we don't miss out anything. The state will take this as a first ground. Our written notes was not taken and we don't want to take any more risks. In so many matters, Mr. Gali, we dispense with affidavits for the sake of expeditious hearing of the writ petitions. 90% of the matters, Supreme Court remands, not this bench only, remands on the ground that no affidavits are direct. So, anyway, affidavits have to be required. It's a cardinal principle we have learned when it entered into practice within 7 days, that unless some factual dispute is to be raised, it cannot be done on affidavits. And a memorandum is the advocate's drafting, affidavit, its client's version. So therefore, unless there is something factual which is to be controverted, we don't require affidavits. Not required. If all the papers are there, we just say that these are not admitted. That's sufficient. On arguments of law, I mean, both sides can make, but that is not that concept is being changed now.
Everywhere affidavit needed.
We won't be surprised if you see that since no affidavit was directed against a memorandum of appeal, therefore that day is coming.
No, it's happening in lower courts.
People like us will be going up, and these days are coming.
In civil division also nowadays affidavit opposition is
It's happening.
Substantial. I have seen an order actually, our High Court's order admitting a civil divisional application on substantial question. What are you saying? Next matter.
Item number 17.
Yes.
Lordship, I'm appearing on behalf of the private respondent number 5 in item number 17 and 18. I'm being led by.
Apart from that prayer, anything else?
Lordship, I'm praying for an adjournment for.
No, we are refusing. Sorry. Yes, Mr.
I'm for the
You are for the state.
I'm for the
Private respondent number 5.
Yes, what is the matter?
order. I have been inducted as irrevocable licensee in respect of this property.
You are also for the other private respondents.
yes, I am the original owner, my lord, recorded owner, who has sold the property to the private.
Are you supporting your learned friends? Yes.
So, my lord, I have been inducted as irrevocable licensee, and my lord, my previous landlord in the meantime has sold the land in favor of my learned friend. Previously, there was a proceedings before the suit court, and my lord, suit court has granted status quo order in respect of that particular suit schedule land. Now, my lord, my learned friend's client has come up with a mutation application. Then mutation application was rejected by the concerned BLLRO, citing that there is a suit pending, challenging that BLLRO's order.
There.
Yes. Challenging that BLLRO's order, my lord, the appeal was preferred under section 54. My lord, the appellate authority has also said in the same line, and thereafter, my lord, this tribunal. And my lord, tribunal has said that since there is no restraining order upon the BLLRO not to mutate, so there is no embargo, and my lord, then thereafter, my lord, directed that BLLRO can go ahead with the mutation proceedings.
Mutation application had been filed prior to the status quo.
My lord,
We'll have
kindly,
to
my
take
lord.
that first.
Yes.
Let us proceed by the process of elimination.
My lord, 17th March 15 status quo was granted. Right, correct me. Yes. Challenging that order, well, they have come up before this court by filing a revisional application, and my lord, that was again remanded. Again, my lord, after remand, the lower court heard all the parties and again passed the status quo order. So this is the fact.
No, when was the mutation application filed?
My lord, mutation কবে ফাইল করেছে? 2023.
Mutation application filed.
Yes.
During this remand and all, was there any period when there was no status quo? It was set aside or stayed?
Yes, during when the revisional court has passed the order and then thereafter reconsidered by the court below.
Was the mutation application filed during that period?
No, no. My instruction is after that. Now, kindly come to page 57. This is the proceedings under section 50. Well, it started on 2nd January 2023. On two scores, one is claimed plot does not match with the field verification. Petitioner does not possess the plot. Document produced do not match with the claim. Not satisfied and hence rejected. And as per order of the learned civil judge, Junior Division, Howrah, there is a clear status quo of the suit land until the disposal of title suit number such and such. Till now, the said TS case is pending before the Honorable Court. If any dissatisfied, may prefer an appeal under section 54. That was the observation. Then, my lord, kindly come to the appellate authorities order. That is starts from page 60, and my lord, kindly come to the page 61. Order dated 19th September 2023. And I'll kindly straight away come to page 62. Well, the appellate authority is neither be judicious nor be appropriate to step into the exclusive jurisdiction of the Honorable Civil Court. It is prudent to not to step into that domain, as this may cause overlapping in judgment of competent court of law. The prescribed authority and revenue officer has to wait for the solemn direction of the Honorable Court, and prior to that, making any alteration or revision in the ROR will intrude in the area of the Honorable Court. In view of the above facts and circumstances, I am inclined to turn down the prayer of the appellant and upheld the order passed by the prescribed authority and revenue officer.
This
Challenging this,
juncture, apparently the revisional court's order had been passed, but it had no status quo had been granted till then, subsequently. Because it refers to the revisional court's order and refers to the pendency before the civil court. Not that subsequently a further status quo order has been
no,
passed.
well, further, it was subsequently granted. That is,
7/3/2015 was the first status quo.
yes.
Came up in revision. When
Yes.
was this,
Then
lastly,
thereafter remanded. Then
was it lastly passed?
I'll
July 2024.
24th July 24. Very good. So why are you asking for adjournment? You're sufficiently competent. 24th July 24.
2024.
Thank you.
So
that is- So in the interregnum, you had filed. They had filed the mutation application.
Well, kindly come to page 52. Interregnum pediatric. সেটাই চর্চায় জানতে।
There were two questions, Mr. Dhar. Whether this prevents the authority from mutating the property because the authority was not a party and no status quo against the authority. One. Secondly, whether mutation tantamounts to change of nature, character, or position. This question is also involved.
Kindly protect my client's interest, my lord, for the
By mutation,
sake of
mutation is an
multiplicity of proceedings,
no,
my lord.
mutation, that is a different thing. But you did not obtain any injunction from dealing with the property. Even if it was dealing with the property of or some language akin to it, we could have understood, Mr. Dhar.
My lord can grant me that.
No, we
right.
cannot grant you status quo now. It has
But
been
in
granted.
respect of the not to
How can we? Why should
alienate.
we? We are in seizing over a challenge against an order whereby the tribunal held that this status quo does not prevent the authorities from mutating the property, which we find prima facie to be correct, Mr. Dhar, because this is the order passed. Mutation is, first of all, does not change the nature or character or position of the suit property. Best argument you can have is changes the character of the suit property, but mutation does not change the character of the property.
My lord, I have a factory.
There's a distinction
there.
between nature and character.
My lord, I have a factory there, and fittings, fixtures, all things are my
That
lord,
is
lying
something
there.
entirely different. But your sole ground is that due to the status quo order, this could not be done. Mutation does not affect your rights. Otherwise, that will be subject to the outcome of the suit.
Yes. Concluding paragraph of the tribunal.
That has to be.
And my lord, I'll have to show then Mr. Mahata's counterpart's argument before the tribunal.
Whatever it has now
So what you are
merged into the order of the tribunal.
my lord. It is now, however, clarified that any
And the
mutation
state
effect having
respondent
none of the
also supported the impugned order contending that
violation of the title suit.
Malad,
Very good judgment.
all our Malad coordinate benches Malad has said Malad, if there is a suit Malad, the revenue authority must Malad wait. Yes, Malad. দুজন জজ সাক্ষী দেবেন।
একটু কপিটা দিল।
হ্যাঁ দিচ্ছি
Citation to the text.
আরেকটা দিতে পারিনি, সরি।
Citation গুলো একটু দিয়ে দেবেন।
First one, it's not clear what was the matter before the court. Having regard to the fact that the proposition is laid down, that civil suits, and in that case, court did that. Having regard to the fact that civil suits are pending between the private respondents, such and such, BLO cannot correct the records of rights in the manner as it was paid for by the title dispute is pending. There a direction was sought upon the BLLRO for correcting the records of rights.
Yes.
That,
And
positive,
now,
positive direction was not given.
now let kindly go through the second judgment.
But in
where,
this case, it's the reverse.
yes.
It has been mutated. A challenge has been thrown to that.
Now let kindly come to the next judgment.
Chandranath Khan.
Chandranath Khan.
Yes.
There was a proceeding under section 50 is pending before the BLLRO Panchla, and having regard to the fact that title suit being number such and such is pending between the writ petitioner and the private respondent in the court of the learned civil judge, First Court, Howrah, concerning a dispute relating to the title in the suit property, hearing of the said proceeding for correction of the record of right was adjourned sine by the concerned BLLRO. Challenging the said order, a tribunal application was filed by the writ petitioner before the West Bengal Land Reform Tenancy Tribunal. And the said application was registered as way such and such, and the said tribunal application is fixed for hearing on 16 June 2015 for expediting disposal of the said tribunal application. The writ petitioner has filed the instant writ petition, then having regard to the fact
That
that
was the feeling of the court, not any proposition. We feel otherwise.
then
What is the ratio of this? There is no proposition laid down. There has to be a point, a counterpoint. Then there has to be a synthesis which leads to a proposition of law. We feel that no, it was done rightly.
very recently, one of the judgment was
You have missed out one. Dipankar.
oh.
No, Mr. Dipankar was appearing for the petition. WPLT 300.
Yes.
Give all these copies to them.
I have given. Having regard to the fact that the civil suits are pending between the private respondents and the writ petitioners concerning
Paragraph? Which paragraph?
it's first paragraph. The only 2-3 paragraphs.
No, this is WPLT 300 of 2014.
Oh,
which has been
Malad has read WPLT 140. Oh, now
Akriti Vapar we have
yes.
seen.
The last paragraph in the first page or just before the penultimate paragraph, we are informed that some of the private respondents have instituted title suit number such and such in the court of the learned civil judge, Junior Division, First Court at Chinchura, Hooghly. The suit is pending. Ad interim injunction was refused, but in appeal, the learned district judge passed an interim order.
There is a distinction between these cases and your case. What is the distinction? You tell us. Your head nodding your head. Tell us. You know it.
Title.
Not only title. No, not only title. We are not on title only.
An injunction.
Here, matter was pending before the BLLO. Sought to be expedited either by this court's direction or by the tribunal's direction. There the court said, no, stay your hand because the civil suit is pending. The question here is whether if a mutation order has been passed, whether that is vitiated. Here a mutation has been granted. You are challenging that. The question is March.
In our case, mutation has not been granted. By citing the second case, like
then it's similar. Yes.
Chandranath Khan. Pending, BLLRO said.
Oh, right, very good. Then these are journals. Yes. And what about the last one? Yes.
And the last one, from my lord's court, one of the parties went up to the Honorable Supreme Court, and Supreme Court in that matter, has stated that first decide the suit court and then all the revenue authority. The second page,
If my lord wants me to, I can read the entire.
What was the context of that?
My lord passed the order by citing that let that civil court decide. In the meantime, you mutate the respective shares. Two parties are at loggerheads. So one party is seeking 1/4 share, another party is seeking 3/4 share. And in that backdrop of the case, my lord directed the concerned BLLRO to mutate respective shares. And Supreme Court has not intervened in respect of that particular thing, but said that let the civil court decide the fate, and subsequently the revenue authority would effect the change if necessary. Oh, right. ওদের কপি দাও তো। হ্যাঁ, এটা সুপ্রিম কোর্টেরটা। এটা আকৃতিটা যেটা দিতে পারিনি।
Right. Yes.
And my lord, I'm sorry, my lord. I'm grateful to my learned junior friend, my lord. He has pointed out that in the suit court, revenue officer is a party.
Revenue officer is a party.
Yes.
What is the suit about?
Suit for declaration and permanent injunction, my lord.
That changes the complexion entirely. That is the first thing we should have pointed. Where is the plaint?
And the plaint is not annexed.
How do you know?
There is material suppression before this learned court.
So we'll come to that. We'll come to that. Don't have a plaint. How do you know revenue officer is a party? What is the suit?
My lord,
That-
yes. ওটাই একটাই আছে। একটাই আছে, দুজন জজ সাহেব।
Because your initial argument was that due to the status quo order, this should not be done. Now you are shifting your argument to the pendency of the suit also should be a deterrent because the title will be decided. Now that's on a different point. These judgments are all on the second point.
Kindly excuse me, my lord, I have just.
Let us see the plaint at least. Yes. Don't you have a better copy?
My lord, I'm providing, my lord, if there is another copy from my lord Justice Bhattacharya. Declaration hearing.
So you have sought for a decree for permanent injunction restraining defendant number 1 from mutating its name. No injunction against the revenue officer.
In effect, my lord,
And BLRO has been revenue of the pro forma defendant.
That we have seen. No, but the other judgments remain. That even
Yes.
pendency of the suit should not. And in the context of the revenue officer being a party, pro forma or whatever. And mutation also, there is a specific injunction, but that's against the private defendant, even then. Anything else, Mr.
No.
What was the logic of the tribunal? Let us see. These judgments must not have been. These were cited.
no.
Unfortunately,
no.
Officer being a party, also that I could not find in the June judgment. Probably it was not the Milord. I have not
Yes, the
seen a
plaint.
copy of the
Plaint.
OA. because, Milord,
See the plaint once. Pro forma And relief E or F is that restraint against defendant number 1 from getting his name mutated.
Probably section 80 leave.
Don't know.
There is no
Nothing.
averment, my lord. I don't think.
No.
That would, my lord, also.
Might be somewhere near about the cause of action
Yes,
paragraph.
my lord, I couldn't find
We
it.
check up whether there is. Section 80 has been complied with. Leave has not been sought. So whether they have complied with prior notice has been given.
I couldn't find it.
Couldn't find it.
But there is no averment, at least in the
No relief also against the revenue officer.
only pro forma. So then the question of, my lord, and my lord,
We will come to
Yes.
Mr. Thodi of
Yes.
Yes, we'll hear him first. Let him.
Yes.
Your Lordship, if I may, there is there are material facts which has been suppressed before your
Like?
Lordships.
You are for respond number?
I'm for private respondent number 5, your Lordship.
Yes.
Your Lordship, the complete documents of the OA before the learned tribunal has not been placed before you. The vendors, the original owners of the land, they were parties to the petitioner. They were directors of the petitioner at that relevant point of time. In 2009, the vendors who were also directors, managing directors, it's a family-run company. They were also they were our vendors. They sold us the property in 2009. In 2013, they resigned from the directorship of the company. 2014, they filed the title suits, saying that the deeds of conveyances, which
You are a
is
company.
I am also a company, Your Lordship. The deeds of conveyance which are signed, they are fraudulent. We were not aware that we were signing the deeds of conveyances. And they filed multiple suits to that effect. Your Lordship, in the title suit originally filed by the company petitioner over here, there is a order of the learned court.
Company is the petitioner here.
Yeah, the company is a
Suit
petitioner.
was filed by the company itself.
The suit was filed by the company along with the vendors, and the vendors subsequently withdraw their suits, saying that we are no longer interested in pursuing, but the company remains. But the company had a change in directorship. They are pursuing the suit.
You had purchased from the company.
I had purchased from the vendors, original vendors of the land, original owners of the land.
My clients.
Original owners of the land.
The company was a licensee. The appellant before your lordship, the petitioner.
They seek declaration of irrevocable license as well as ownership in the second pair. You have seen that. Yes, what else was suppressed?
In the title suit,
We're not going into the merits of the title suit. We are on a very short point. Whether this the mutation proceeding should have been concluded, irrespective of pendency of the suit and the subsistence of the status quo. What is your argument?
I'm on that point, Your Lordship. In the title suit itself, the learned court has held. Now any relief granted should be which authority? Until get a decree of a civil court cannot pass any order upon the mutating authority to restrain it from mutating the name of any
Which
person.
page?
This is not part of the records, Your Honor. This is a order passed by the learned trial Your Lordship. This order was passed by the learned trial court 15 in their suit 15th March 2023. This was part of the records in the OA, which has not been completely.
No, but that order has now merged into the last order of status quo because it came up in revision and it went back.
Yes, Your Lordship.
So that cannot be a relevant consideration. The last order 17th, the last order which was placed 24th of July 2024, that is to be seen.
They have called us the owners of the suit property. They have filed an appeal against that order. We have also filed an appeal against that order, saying that they are constructive possession. The learned trial court has held.
Appeal, pendency of appeal does not operate as a stay.
In the last page of the order, Your Lordship, there has been stated the defendant number 1 is the owner of the suit land, being delivered khas possession of the suit property. Defendant numbers 2 and 4, who were the original owners of the property.
Yes, but status quo has been granted. Both parties have been directed to maintain status quo as regards the nature, character, possession of the suit property. So how did you proceed with the mutation in the teeth of the status quo? You also have
application was prior to the.
You had made that.
Yes,
application was prior, but you could not proceed. Certain formalities have to be done.
Mutation has not been concluded as of yet, Your Honor.
So how could you proceed with, because mutation isn't it in a sense a change in the character of the property? Because if it's recorded in the name of somebody, mutation is prior facie proof of possession also. So doesn't it tantamount to a change in the possession of the property?
Your Lordship, in the
broader sense.
Your Lordship, in a CO 1753 of 2019, Justice Pratik Prakash Banerjee ordered an inspection of the suit property. An inspection report has been filed. It is part of the records of the OA. Over there, possession was deemed in our favor.
We don't know that.
There are orders
no,
to
no.
that effect which has been
Maybe, but here it's recorded. Here in this case, yes, status quo, the status of the defendant is, oh yes, right. Defendant number one is the owner. Oh, having possession of the suit land.
possession of
You are defendant number one.
I'm defendant number one. And constructive possession has been deemed in a there, but we have preferred an appeal against that.
Plaintiff is not in actual and physical possession,
Yes, sir.
but has constructive possession. It has been found by the civil court, and you have actual physical possession.
Yes, Your Lordship.
So you say it will not be a change of the possession also.
Yes, Your Lordship.
Well, please take your seat. We'll just see.
Grateful, Your Lordship.
Yes. State last. State last. As usual.
My role is very limited, my lord. I was the original owner. But I had executed the deed of conveyance
Yes.
in favor of the private respondent number 5 being the defendant number 1 in that.
Mr. Dhar, is there a seat beside you?
Yes.
You can shift one and let him
Yes.
sit. He's the main arguing counsel.
Also.
Yes. Yes.
We had executed deed of conveyances in favor of the defendant number 1 in the suit being the private respondent number 5 here.
Right.
Now, my lord, there was a dispute between us and the private respondent number 5. Now, my lord, in those suits filed by the, my lord, I am for the Kundu family. The Kundu family, my lord, had sought declaration for delivery of and cancellation of the sale deeds. Now, my lord, there is a company which was originally owned by Kundu families, which, my lord, was there up to a certain period of time, my lord, prior to the sale deeds were executed. Now, my lord, upon sale deeds being executed, possession was handed over. Now, my lord, in 2014, this company, which is the writ petitioner before your lordship, my lord, filed a suit claiming for those reliefs, my lord. And I have not seen the print because, my lord, I was also, my lord, it's not there, my lord. I got it yesterday, my lord. So the OA papers haven't come, so my lord, I could, my lord. But then, my lord, what transpires from this order and the subsequent events, my lord, today the fact is Kundu family has withdrawn all challenges to the execution of the sale deed. But that's one part. Now, my lord, secondly, my lord was looking at page 56. It kindly comes back to 55, my lord.
Yes.
I'll just trouble your lordship for one more paragraph before that. On the bottom of page 55.
Yes.
Now, as to the argument led by the
You are for which of the respondents exactly?
my lord, for the private respondent, my lord.
What is your name? Full name? Your.
My name,
Not the company. You as counsel.
Hirannak Gangopadhyay, Your Lordship.
Hirannak
Gangopadhyay.
Thank you.
Grateful.
But I'm for 6. my lord.
You are for 6. You are for 7, right? Yes.
At page 55, learned trial court my lord, takes into consideration, my lord, the local inspection report. And then, my lord, this is what it records. Now, as to the argument led by the learned counsel for the defendant number 1, that the plaintiff company being out of possession of the suit property cannot get the protection of injunction and without praying for recovery of possession, the instant suit is barred under law. Though it is a fact that a person in actual physical possession of the suit property should be protected by an order of injunction, but since the plaintiff company has factory shed along with plant machinery and structures upon the suit land, therefore they are also in possession of the suit property, though not in actual physical possession, but in constructive possession of the suit property. Moreover, if the plaintiff company is out of possession of the suit property and they have not paid for recovery of possession of the suit property, then the plaintiff shall face the consequences in the suit. The Honorable High Court, my lord, and then a case has been referred to, my lord. I'll not trouble your lordship with that. My lord, therefore, on the next page, thus the 3 ingredients for obtaining the equitable relief of injunction, that is the prima facie case, balance of convenience and inconvenience and irreparable loss and injury, is required to be satisfied for obtaining an order of injunction. The plaintiff has established its prima facie case of being an irrevocable license as to its factory shed upon the suit property and running its business therefrom at the time of institution of the suit, and subsequently ousted from the suit property by the defendant number 1. Thus, the balance of convenience and inconvenience also slightly tilts in favor of the plaintiff company, for if the injunction so granted is not granted in favor of the plaintiff company, then the defendant number 1 might change the nature and character of the suit property on becoming the owner of the suit property land. And if subsequently the plaintiff company is able to establish its case in course of trial, then irreparable loss injury shall occur to the plaintiff company for such change the nature and character of the suit property.
Now, the Honorable High Court at Calcutta has directed this court to determine the status of the parties to the suit before passing any order of injunction. On the basis of the above discussions, it can be precipitated that the defendant number one, this is where I emphasize, is the owner of the suit property and is being delivered khas possession of the suit property by the defendant numbers 2 to 4. However, on perusal of the ROR, it appears that the suit property is still recorded as Sali Karkhana. Prima facie case, it appears the factory shed has been established by the plaintiff company, but being ousted from the suit property, the plaintiff company is not in actual physical possession of the suit land, but has constructive possession of the suit property. Now, this is where, my lord, the
But
findings.
difficulty, there is one difficulty that here the court finds on the basis of the recording in the RS records, the records of rights themselves,
Yes, my lord. Sali
that
and
it's,
Karkhana.
yes.
You know, those
So if that is changed during pendency of the suit,
so there,
then these judgments, the ratio of these judgments should come into
there
play.
are two aspects to it. That's why, my lord, I wanted to show, my lord.
That position will be changed then.
Yes, my lord. That's why, my lord, I took your lordship.
We are not going by the status quo strictly.
No,
Pendency of the suit.
that's why, my lord, I took your lordship's back, my lord. So, my lord, what is the
Right.
claim of the plaintiff? My lord, not on land, not on physical possession of the land. My lord,
Irrevocable license on land.
My lord, irrevocable license, which they are not in possession. My lord, loss of possession and irrevocable license, my lord, are a little difficult to reconcile.
No,
But
but the court
license-
finds that during at the inception of the suit, they were in possession.
Yes, my lord.
If they were ousted illegally, then
Now, there's an appeal pending, so, my lord, but then, my lord, naturally, there's no stay, so, my lord, and
As
I'm
of
also
today,
not aware of, my lord, the orders, my lord, which my learned friend showed of 23, whether it was in this application or a different application, my lord, I'll have to check, my lord, I'm not aware. There may have been, because, my lord, why I say so, this order, he says, is of 15th of March 23. Now, my lord, why my lord, I have a doubt, kindly comes back to page 38. But
Yeah.
kindly see, this is the order of the civil revision.
Huh.
But kindly see the date of hearing and the impugned order. 14th January 2019 was the impugned order. And the order by which the direction to, my lord, stay or restrain the BLRO from effecting mutation is of March 23. And the status quo order is of July 24. So, my lord, unlikely that it could have been in this application. No, that was a separate application, ought to be. Not because my lord, the order 39 had been allowed, but confirmed in appeal, pending before our High Court, my lord, in civil revision. In the meantime, my lord, an order is passed in March 23. So, my lord, I'm not sure, my lord, but my lord, looks like it was a separate application.
Maybe.
My instruction is on the same application.
So, my lord, if
I appeared on behalf of the defendant number 2 in the trial court. That is the same application. It was detailed hearing. Now I supported with the trial court. Now the change of advocate is standing still.
my lord, I don't know, my lord, so therefore, my lord, I don't want to make a comment on that. But, my lord, since the present owner, my lord, showed.
No, we will continue after recess. Will continue. Yes, please.
I was, my lord, I had just placed the order, my lord, of the trial court granting at page 56.
Yes.
My lord, one information that, my lord, I could gather, but kindly turns over the page and come to page 57.
Yes.
My lord, the mutation application case number is probably of 2013, my lord, not of 23. And my lord, this is confirmed at page 40, that is the revisional court's order by our court, but kindly comes to page 40. Para 4. But, 5 lines from the bottom. On 1st November 2013, the appellant defendant had applied for mutation of the suit property. So, my lord, it's before the filing of the suit. The suit is of 2014. Now, that's the one information, my lord, which my lord had asked my learned friend. So, my lord, it's not, my lord, during the pendency of the suit or, my lord, the gap between orders, my lord. The application was there before the suit was filed. Now, my
This is generally on the see the status quo per se may not be violated, be restrained on, but the pendency of the suit itself has been held by several division benches and the Supreme Court.
my lord,
That
these
is
are
what is
orders,
playing in our
my
mind.
lord, my lord, I also went through, my lord. My lord, there are
Not-
judgments, my lord. I'll just keep
Judgments
it
as
over
well.
there, my lord. Now, my lord, in our case, my lord, there is a little difference, my lord. I
How-
don't want to cite cases on suppression, my lord. But, my lord, there is suppression, my lord. Why I say, my lord, the order, my lord, which somebody paragraphed, my lord, and said that no, it was not. My lord, I've tried to take out copies of those orders, my lord. Kindly see this. My lord, this was an application filed by my learned friend complaining to the trial court while the first injunction order was there, status quo, saying that the transferee is proceeding with mutation in the teeth of the injunction order, status quo order. But kindly sees, my lord, this is a separate application, my lord, not order 39 rule 1 and 2. But it was application under 94C. On the first page, my lord, kindly sees, my lord.
In violation, yes.
Now, decision with reasons. My lord, I'll just the relief under 94C is a supplementary one, and the said relief can only be granted if the plaintiff can show that there are change in circumstances which necessitate such order. Now, any relief granted by this court should be such which is implementable by itself. Civil court cannot pass any order upon the mutating authority to restrain it from mutating the name of any person. Even if the right of a person upon a property is established after the trial and eventually he gets a decree of declaration that he is the true owner, the civil court cannot direct the BLRO to correct any mutation entry which is against the interest of such person. What the said decree holder can do is make an application before BLRO intimating the fact of the decree passed in his favor and to pray for necessary correction of the record of rights. The process of mutation entry is governed by a specific statute, that is Land Reforms Act. The revenue officer is empowered by this act to mutate the name of the person in the record of rights after being satisfied with the fact that the said person has right, title and interest over the property. The entry in record of rights do not create any right, title and interest over the property. Title of a person over a particular property can be created either by a registered instrument or by a decree passed by a competent court. Hence, it cannot be said that by trying to mutate his name, the defendant number 1 is violating the order of status quo in any way which necessitates interference. Lord, my instructions are, Lord, this order has never been challenged. And Lord, the first order of status quo, which was interfered by my lord, our court in the revisional application, was on the ground that the status was not determined. It was a blanket order of status quo. So, my lord, it did not restrict itself to nature, character, and possession. The first order, my lord, of which violation was complained, and the court interpreted.
This 15th of March order was challenged before the revisional court.
No, my lord, it has not been. Now, that's my instruction, my lord. The plaintiff, that is the petitioner before your lordship, has accepted this order and my lord has suppressed in the present writ petition that this prayer was rejected. Now, on that ground alone, my lord, without going into merits, my lord, the writ should be dismissed. That they ought to have come and told your lordship that this is what has transpired in the suit.
How did a revision lie against a status quo? That is what we are wondering.
My lord, the revision came up from the appeal court's order, my lord.
Oh.
My lord, that came through that route, my lord. Order 39, my lord, injunction, appeal, and then the revision. So, my lord, the plaintiff, my lord, suppresses this order. And my lord, plaintiff, my lord, accepts this order. My lord, both things are there. Now, my lord, the impugned judgment, my lord, takes notice of all the judgments, my lord, which are there from 97, my lord, Balwant Singh, etc. My lord, that mutation does not create any, my lord, right, title, and interest. My lord, this order also interprets its own order, my lord, the trial court, as to what it meant while granting the injunction order, my lord. And this is despite the fact, my lord, the revenue officer was a party. But I've checked up, there is no pleading also relating to dispensation of Section 80, let alone, my lord, any leave. So, my lord, and a pro forma defendant, my lord. Now, these are the two factors, my lord, as to the effect of the injunction order. But also, my lord, I'll borrow a term used by my lord, corporeal, my lord. So, my lord, the trial,
Corporeal, yes.
my lord, the trial court has, my lord, that order, my lord, of July 24 has also not been assailed by the plaintiff. So, my lord, what it accepts that the defendant number 1 is the owner. Defendant number 1 is in possession. Now, my lord, there is no application for conversion, my lord. Kindly, my lord, consider this, my lord. There is no application for conversion. So, my lord, today to preempt a situation which has not arisen, that, my lord, if I get mutation, my lord, mutation is allowed, there will be conversion, and therefore change of nature, character, my lord, is premature at this stage, my lord. That will arise only if and when, my lord, an application for conversion is made. Today, it's simpliciter, my lord, only mutation of an application filed prior to filing of the suit. Interim order refused, clarified that no injunction. I'll just, my lord, also rely on your lordship's judgment, my lord. I couldn't find the reported copy, my lord. This is dated, my lord, 19th January 2026, passed in WPA LRT number 206 of 2025. I am, my lord, only relying on paras 17 and 18, where, my lord, also a suit and injunction was there. I could not, my lord, locate whether the revenue officer was a party or not. But, my lord, in our suit also, my lord, effectively it's not a party because, my lord, Section 80 leave, my lord, I think has a bearing on the effect of that injunction or an interim injunction against a government authority. In para 17, I'll just place, my lord. It is further clarified that the order of injunction passed in the title suit to the effect that the parties thereto are restrained by order of status quo from altering the nature, character, and possession of the suit property shall not in any manner be construed to be an injunction order on the tribunal, restraining it from proceeding with the adjudication. It is well settled that an order of injunction binds only the parties and not any tribunal or forum, and in any event, an adjudication by the tribunal shall only affect the legal nature of the possession of the parties and not the nature, character, and possession of the suit property in its corporeal sense. Hence, such adjudication shall not be violative of the status quo order passed by the civil court in any event. Thus, the tribunal is free to proceed, my lord. So, my lord, in our case also, my lord, the application, my lord, predates the suit. My lord, res judicata, my lord, also operates, my lord, in the interim stages, and the plaintiff having accepted 15th March order by the learned trial court, clarifying that the status quo order was never meant to extend to the mutating authorities, my lord. And, my lord, of course, suppression, my lord, being primary, my lord, that ought not to have been done. Now, my lord, so far as the cases, other cases cited, my lord, of our court, my lord, those are only, my lord, not laying down any law, my lord. So far as I could, my lord, go through them, my lord. They have noticed, and there were applications for expeditious hearing, my lord, largely to dispose of the matter, where the courts have not allowed those prayers, my lord.
But on the ground that the suit is pending.
On the suit is pending. So, my lord, those are my submissions, my lord. I have, my lord, I was, my lord, also objecting to this, my lord, I should be candid, my lord. I am the original owner, my lord. And, my lord, I was objecting to the sale deed, my lord, which suits have been withdrawn, my lord. And, my lord, I have confirmed both, my lord, the sale deed executed in favor of the private respondent number 5 and, my lord, the possession having been handed over, which of course is corroborated by the trial court's order, my lord, of July 2024. So those are my submissions.
You are for one of the other owners or?
No, there are two, my lord, 17 and 18, my lord, so two owners.
Oh,
two Khatyans, my lord.
18 is, we are also hearing item 18.
I think একসঙ্গে
Yes.
করছো।
18 টা দেখে দিতে হবে। Yes. থাক এখানটা, দিয়ে দিন এখানটা। Hide করে দিচ্ছি।
কি আছে?
I will not repeat what Mr. Kanodia has said. I'll just sum up. A, that property was sold in way back in 2009. There is no dispute with regard to that. The defendant number 1 today is the owner or the respondent number 5. There is no dispute or there is no suit as regards to any challenge to that sale. The petitioner has filed this suit claiming declaration, if your lordship sees, two things. One, declaration that is a irrevocable licensee in respect of the suit property.
Yes.
And the second, declaration that plaintiff company is absolute owner of the entire factory shed together with plant machineries installed, not the land. Not the land. That is one. Second, if your lordship takes page 83, 84 and 85.
Eighty-three.
Page 83.
Yes, 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 yes.
See, if your lordship sees the অত্র সত্ত্বের দখলদারের বিবরণ,
You are the Kunduz.
the kundus are there. Nowhere the petitioner's name is there. So today, mere the changing of the mutation name,
So it will be changed not from his name to yours.
right? It is their document. ওই সুপ্রিম কোর্টে একবার ধরিয়েছি, এখানেই আছে।
You and Mr. Kanoria are the Kunduz.
Kundus. This is for Deepak Kundu. I am for Archana Datta, the legal heir of another Kundu. And as Mr. Kanoria has indicated, this is the judgment of Jitendra C. 2021 SCC online. The lordship takes paragraph 7 onwards. That has also been referred to the impugned judgment. Right from 1997, the law is very clear. In the case of Balwant Singh and Daulat Singh, reporting, this court had an occasion to consider the effect of mutation, and it is observed and held that the mutation of property in revenue records neither creates nor extinguishes title to the property, nor has it any presumptive value on title. Such entries are relevant only for the purpose of collecting land revenue. Similar view has been expressed, and that has been followed in series of judgments.
Settled position.
And if a lordship takes the impugned judgment of the tribunal,
Yes.
from page 5, internal page 5. In the present case, no material has been placed before this tribunal to demonstrate that any specific order has been passed by civil court restraining the mutation process. So there was no injunction with regard to that. General order of status quo in respect of nature or possession of property cannot automatically be construed as an injunction against correction of revenue records, particularly when mutation does not determine the title and remains subject to the final adjudication of the civil court. From the materials on record, submissions advanced, it is palpable that the appellant derives title under 2 registered deeds of conveyance dated December 12, 2009. Execution of such deed is not denied. The claim of respondent is founded upon alleged license and possession. Even assuming 7 is an irrevocable licensee and is running a factory, such claim does not eclipse the prima facie ownership flowing from a registered conveyance. The question of nature, extent, and enforceability of license is a matter squarely within the domain of civil court. Appellate in considered view misdirected itself in law in declining interference solely on the ground of pendency of the civil proceedings. Mutation being fiscal in character and subject to the outcome of civil litigation, there was no justification in law to refuse mutation merely because matter is sub judice. And by this judgment, it has merely referred back for reconsideration. There's no final fate to it. If your lordship comes to the penultimate paragraph, it says, in view of the foregoing discussion, impugned order dated so and so passed by appellator under section 54, application cannot be sustained and is accordingly set aside. Matter is remanded to the concerned BLR Domju to reconsider and process the mutation application strictly in accordance with law. If in accordance with law it's allowed, it's allowed. It does not decide any fate. And as I always said, they don't have right. Even in the existing records also, their name does not appear. Those LR records.
Yes, Mr. Dhar, what is it?
Yes.
The state.
Mr. Mahat. Yes.
My lord, yesterday my lord had already decided a similar question. If your lordship kindly come, page 62 of the my lord petition, the appellate authority the same language. The appellate authority neither be judicious nor be appropriate to step into the exclusive jurisdiction of the Honorable Civil Court. With regard to the mutation, then what about section 50 and 61 of the Land Reforms Act? And my lord, I will know argue further because my lord, kindly come to the inner page number 5 of the judgment.
Yes.
The last paragraph. It is, however, clarified that any mutation effected in favor of the applicant shall remain subject to the final decision of the title suit. Well, it is justified.
Yes, Mr. Dhar.
Yes. No. Let me show the first the stand taken by the respondent number 5 before the Land Reform Tenancy Tribunal.
What is
This
it?
was the affidavit filed by them.
Outside judge.
Affidavit they have used
Affidavit we cannot look into. Orders we can look into. Orders of
affidavit in opposition in the OA.
what was this?
Well, they have supported, yes, appellate authority has done the right thing because several, may I read the particular paragraph? That the answering respondent number 5 herein state that during the pendency of so many civil suits in between the parties herein, if this
The
original
new argument you are making in reply, Mr. Dhar. You should have pointed this out. After their arguments are concluded, you are making out a completely new point. And that too on something which is not a part of the analysis.
after taking the stand of respondent number 5 here, that they
So this should have been in your first argument. They're obviously they are opposing it.
then
Anyway, what is this? What did they say? We have several pendency of several litigations.
The application for appellant hearing is if this original application of the appellant hearing is entertained and allowed without ascertaining its claim of ownership over the suit property in question herein by the competent civil court, the answering respondent number 5 herein would suffer irreparable loss and injury.
Please repeat that again.
That the answering
Yes.
answering respondent number 5 herein state that during the pendency of so many civil suits in between the parties herein, if this original application of the appellant herein is entertained and allowed without ascertaining its claim of ownership over the suit property in question herein by the competent civil court, the answering respondent number 5 herein would suffer irreparable loss and injury, and this would also lead to multiplicity of proceedings, and further the litigation would get protracted without any reasonable basis or cause. That was the stand taken by the respondent number 5 before the tribunal.
So then who had preferred the challenge before the tribunal?
Mr. Kanod,
Respondent number 5 had preferred the challenge.
Respondent number 5 before the tribunal is the owner's view.
Respondent number 6.
sorry, respondent number 6 hearing.
You had preferred.
And kindly also that I request Mr.
Dhar to place paragraph
21 of his
Respondent number 5.
See para 21 of the writ petition.
Respondent number 5 is Deepak Kumar বলছে আমি কি বলতে
How is it material? Yeah,
This stand was there before the tribunal also. Kindly sees me the pleading. This was produced. My withdrawal of the suit
yes.
was before the tribunal. It's not like I'm changing now, Milord.
No,
What Mr. Dhar is trying to show my affidavit in opposition.
no, this is not your affidavit. Respondent of 5's affidavit.
No.
Your affidavit in opposition.
No, I was a respondent. I was contesting the transferee.
So,
So thereafter, as I submitted,
Baba,
there's been a
details.
settlement and we have withdrawn the suits, Milord. The previously recorded owners and the vendors in the sale deed.
Yes.
Milord, that's the Kundu family, Milord. Milord, there was an affidavit, Milord, objection to the mutation by the.
No, we don't get it. Both the forums, appellate forum as well as the first forum, dropped the proceeding because of the pendency of the civil suit. Challenge was preferred by your client.
No, Milord.
You had preferred the challenge.
Yes.
Milord, he is the defendant number 1 in the suit where that injunction order was, Milord.
Yes. So respondent number 5 in that proceeding was not respondent number 5 here.
No. Respondent number 6 here.
Because Mr. Kanodia's client who had filed this opposition.
Respondent number 5 in
Whoever.
before the way.
Now that is respondent number 6 here.
Yes.
Yes.
And Milord, before the hearing concluded, Milord, the settlement had happened and the withdrawal of our suits, the Kundu family suit, was brought to the notice of the tribunal, Milord, which is there at para 21.
Yes.
Milord, the opposition
Was filed before that.
Yes. And thereafter, Milord, we abandoned before the tribunal. We said that we have no objection, we've withdrawn the suit. So, Milord, today to say that, Milord, now I have started suddenly, Milord, supporting the transferee is not correct, Milord.
Milord,
His
I
petition
would-
also proceeds on
Milord,
that basis.
I would not
Milord,
say,
we
Milord, that
getting this opposition, Milord.
Milord, I would not say, Milord, that affidavit is only, Milord, I have shown just that they have changed their stand. Rather, they have supported the legal point which we raised throughout. Had. Now,
Before this compromise.
yes, Milord, that legal point, Milord, Milord, I would say, Milord,
That was their argument that was not a legal point decided by
Well,
some authority.
true, Milord,
stand.
supporting
Stands may
a
change.
point.
Maybe.
Now, Milord, kindly come to para 13 at page 8 of my writ petition. That 15th March 2023, we have suppressed several things has been said. Para 13, my lord, your petitioner states that challenging the particular order, we have filed the civil revision, and that civil revision being number 2980 of 2023, which is still pending. It's not the fact that we have not divulged the information. We have divulged the information, as also there is a challenge towards that. And now, my lord, kindly, my lord, have a look to the LA manual once. I'm sorry, LR manual once. My lord, manual 58 and 59.
You are making new arguments in reply, Mr. Dhar. We cannot permit it. Sorry.
Not new,
Completely,
my lord.
all of these are new arguments you are making. You should have made this at the first instance. You cannot invent new arguments after the reply is over. You cannot just do it, Mr. Dhar. This is not good advocacy.
Regarding
You are relying on particular provisions of law.
Regarding-
How can the answer? Again, we'll hear them. Again, we'll come back to you.
regarding possession, they have said that they have taken over the possession. My lord, for that, my lord, I need to show.
But these provisions of law you should have cited at the first instance. That their stand is always there. Dekhi rule din. Completely new arguments in reply. This is very bad practice, Mr. Anyway, let us see rule whatever.
No,
50?
59.
Yes. Inquiry and verification. So what?
At the time of mutation, this inquiry, my lord, has to take place.
Yes.
And my lord, when the learned civil court has, my lord, has held that during the pendency of the suit, my lord, the possession has been taken away from us illegally. And now there is a challenge by us as also by them. Well, how the revenue authority is going to that particular aspect of the possession?
What is the significance of 59?
Well, the verify of the physical possession of the applicant.
Yes.
Whoever is coming before the authority by filing a section 50 application, that particular authority has to, upon the deed or
Yes.
transfer deed or something,
Verify physical possession.
then verify the physical possession.
Yes.
Well, now, the two parties are at loggerheads. One is saying I am in physical possession, other party is saying I am in physical possession.
So what?
Well, in that position, well, I would say the first civil court has to decide on that aspect, not by the revenue authority, when the physical possession is in disputed. So revenue authority has to comply with 59 while considering the mutation application.
Land Reforms Act of the anything else?
No.
Good. The present challenge has been preferred.
Just one thing, my lord. Very sorry, my lord. I had handed over this order, my lord. And the pleading, my lord, has seen at para 13 relating to a CO. But as per the pleading,
That's still pending. Yes.
Lord, that's against the second order on the next page of the order I handed over, which was under order 6 rule 17 application. So there were two applications, my lord. I have handed over 2-page order. And I've given a copy to my learned friend. Pleading is, my lord, order 6 rule 17 has been challenged, which is, my lord, a separate order, my lord, which I have handed over. But I have not seen the copy of the CO, my lord. I will not take that responsibility, whether both orders are challenged or not. But the pleading, my lord, is clearly that it.
Very well. The present challenge has been preferred against. So why two revisions? Why two writ petitions?
Two owners,
Two.
mutation from two owners.
Two different quotients. So that's why two
Two
appeals.
applications,
Two-
You are leading your learned friend. Fine. We have heard it. Yes.
18 minutes.
The present challenge has been preferred against an order whereby the learned West Bengal, the West Bengal Land Reforms and Tenancy Tribunal has allowed a challenge against an order passed by the appellate authority confirming the order of the concerned block land and land reforms officer and directing the first authority to decide the mutation application filed by the present respondent number 5 in accordance with law. Full stop.
I'm sorry. Yeah.
Yes. The BL and LRO as well as the appellate authority had turned down the application for mutation primarily on the premise of pendency of a civil suit at the behest of the writ petitioner. Full stop. Next para. Learned senior counsel appearing for the petitioner submits that in view of the pendency of the dispute between the parties before the civil court with regard to the self-same property, it would not be proper if the mutation application is decided by the revenue officer during such pendency. Full stop. In support of such proposition, learned counsel cites 3 unreported coordinated bench judgments of this court, respectively in the matters of WPLRT 300 of 2014, WPLRT 140 of 2014, bracket Akriti Vyapar, Akriti Vyapar Private Limited versus Priyonath Saha and others, and WPLRT 356 of 2014, bracket Sri Chandranath Khan versus the State of West Bengal and others, as well as an order of the Honorable Supreme Court in SLP within bracket C, diary number 68933 of 2025. Full stop. Next para. Learned senior counsel next contends that in terms of the order of status quo granted by the civil court, comma, the parties are to maintain status quo as regards nature, character, and possession of the suit property. Full stop, it is submitted that in the event mutation is effected in the teeth of such order, comma, the same will be in gross contravention of the said order. Full stop, next para, learned senior counsel cites Rule 59 of the West Bengal West Bengal Land and Land Reforms Manual, 1991, to argue that the process of mutation requires an inquiry to verify physical possession of the applicant, comma, examination of the registered transfer deeds and other collection of evidence, comma, which is the subject matter in the civil suit itself. Full stop. Thus, comma, it is argued that since the scope of such inquiry overlaps with the examination before the civil court, comma, the appellate authority as well as the BL and LRO were justified in staying their hands insofar as the mutation case is concerned, comma, in view of the pendency of the civil litigations. So next para, learned counsel appearing for the respondent number 5 within bracket defendant number 1 in the suit filed by the petitioner bearing title suit number 497 of 2021 bracket closed, argues that there has been suppression of material facts before this court. Full stop. It is contended that in the status quo order dated March 15, 2023 itself, comma, it was recorded by the learned civil court that the defendant number 1 stroke respondent number 5 is now in possession, physical possession of the suit property as well as is the owner of the same. Full stop. Next para, that apart, comma, it is argued that the mutation, comma, if granted, comma, shall not be contrary to the order of status quo passed by the civil court. So next para, learned counsel appearing for the respondent number 6 hands over a copy of an order dated March 15, 2023, whereby the civil court, comma, in the suit filed by the present petitioner, comma, had observed that it cannot be said that by trying to mutate his name, comma, the defendant number 1 within bracket present respondent number 5 bracket closed is violating the order of status quo, which necessitates the interference of the said court under section 94 within bracket small c of the Code of Civil Procedure. Which of thus, comma, in the perception of the civil court as well, comma, the mutation in respect of the subject property would not amount to contravention of the civil court's order. Which of next para, it is further argued that the judgments cited by the writ petitioner did not lay down any proposition of law as such, but were orders passed in the circumstances of each case. Full stop. Next para, even otherwise, comma, it is submitted that the scope of adjudication in the civil suit is different and distinct from that of inquiry for the purpose of mutation under the West Bengal Land Reforms Act 55. Full stop. Next para. It may be added that learned counsel for the respondent number 5 also relies on an unreported judgment of a division bench of this court in WPLRT 206 of 2025, bracketed Sohel Ahmad versus State of West Bengal and others. Respondent number 5, respondent number 6, where it was held by this court that it is well settled that an order of injunction binds only the parties and not any tribunal or forum, and in any event, an adjudication by the tribunal shall only affect the legal nature of the possession of the parties and not the nature, character and possession of the suit property in its corporeal sense. Semicolon, hence, such adjudication shall not be violative of the status quo order passed by the civil court in any event. Full stop. Next para, learned counsel appearing for the respondent number 7 herein argues, by placing reliance on the existing records of rights as they now stand, extracts of which are annexed to the writ petitions, that the subject property is now recorded in the name of the erstwhile owners, that is the respondent number 6 and respondent number 7 respectively in the two writ petitions. Full stop. Next para. As such, even if mutation takes place in the name of the respondent number 5 herein, who is the subsequent purchaser from the erstwhile owners, there would be no affectation of the rights of the writ petitioner in any manner whatsoever. Full stop. Next para. Even otherwise, learned counsel cites Jitendra Singh versus State of Madhya Pradesh and others, reported at 2021 SCC Online SC 802, where the Honorable Supreme Court reiterated the proposition that mutation of property in revenue records neither creates nor extinguishes title of the property, nor has it any presumptive value on title, and such entries are relevant only for the purpose of collecting land revenue. Full stop. Next para. Insofar as the title of the property is concerned, the Honorable Supreme Court held that it can only be decided by a competent civil court. Full stop. Next para. Learned counsel appearing for the learned senior counsel appearing for the petitioner argues then that in the affidavit in opposition filed before the tribunal to the original application, which is the genesis of the present challenge, the respondent number 6 had admitted that in view of the pendency of the civil litigations, the revenue officer should not proceed with the mutation proceeding. Full stop. Next para. However, to this, learned counsel for the respondent number 5 responds that such affidavit was filed prior to a settlement between the respondent number 5, respondent number 6 and respondent number 7 in the two writ petitions, as well as the other erstwhile owners, with the respondent number 5, the purchaser from the said owners with regard to the subject property. Full stop. Thereafter, a suit initially filed by the erstwhile owners challenging the purchase deed of the respondent number 5 stroke subsequent purchaser was withdrawn and the matter was settled between the parties. Full stop. As such, it is submitted that the affidavit in the stand taken in the affidavit in opposition, filed prior to the said settlement, cannot be taken into consideration to reflect the current stand of the erstwhile owners. Full stop. Next para. Upon considering the arguments of the parties, it appears to the court that the cardinal issue involved is twofold, as to whether it would be proper for the revenue officer to proceed with the mutation proceeding in terms of the impugned judgment of the tribunal during pendency of the civil suit, and secondly, as to whether, comma, in the teeth of the status quo order passed by the civil court, comma, the such further proceeding with the mutation case should be deemed to stand debarred. For sub next para, insofar as the first issue is concerned, comma, with deepest respect, comma, the judgments in the judgments of coordinate benches of this court cited by the petitioner, comma, no general proposition of law as such was laid down. Full stop. An observation in a judgment is a binding precedent only when it forms a part of the ratio. Full stop. Next para. For being a ratio, comma, an issue has to be specifically argued and controverted and has to be considered and decided on merits. Full stop. However, comma, in WPLRT 300 of 2014, comma, it was merely recorded by the coordinate bench that by the order impugned therein, comma, the tribunal had disposed of the original application and directed the BL and LRO to dispose of the application for correction of revenue settlement record of rights filed by the private respondents, and that the court was informed that some of the private respondents had instituted a title suit which was pending, where ad interim injunction was refused. Full stop. Next para. The honorable division bench, the coordinate bench further observed that the civil court is empowered to pass a decree for declaration of title, and therefore decree of the civil court, comma, particularly when in such suit the state is a party, is relevant for correction of the settlement record of rights, and accordingly accordingly restrained the BL and LRO from considering the application for correction of settlement record of rights filed by the private respondents till disposal of the suit pending before the trial court. Full stop. Next para. However, comma, it is not clear from the said judgment as to what was the exact scope of the suit and the reliefs claimed therein. Full stop. The coordinate bench proceeded on the premise that the state was a party in the suit, and as such, comma, it would not be appropriate before the civil court decided the rights of parties for the block land for the BL and LRO to proceed with the correction of revenue settlement records. Full stop. Next para. In Akriti Vyapar Supra, comma, the coordinate bench, comma, without any reference to the scope of the factual matrix therein, comma, merely observe that having regard to the fact that civil suits are pending before private respondents and the writ petitioners concerning the respective claims of title over the suit property, comma, in the view of the said division bench, comma, the BL and LRO cannot correct the records of rights in the manner as it was prayed for by the private respondents, as the dispute regarding title between the parties cannot be decided by the BL and LRO. Full stop. In Sri Chandranath Khan Supra, comma, the division bench, comma, similarly, comma, expressed its opinion that justice would be subserved if the record of right was corrected immediately after disposal of the suit, comma, by taking into consideration the pendency of civil suits generally. Full stop. In Lipika Datta Supra, comma, the Honorable Supreme Court had observed that the issue brought before the High Court was only the refusal to grant interim relief by the West Bengal Land Reforms and Tenancy Tribunal, comma, pending consideration of the appeal filed by the respondent number 6 therein, and it appeared that the High Court was not apprised of the fact that one Panchanan Mondal had sold 6 bighas, 18 quotas of land pursuant to a decree passed in a preemption suit filed by Panchanan Mondal. First up, in the facts of the case, the Honorable Supreme Court went on to hold that the WBLRTT was only seized of the appeal in relation to mutation proceedings, and it was the civil court which would ultimately decide the rights of the parties in relation to the subject property, and that the decision of the civil court would be binding upon the revenue authorities concerned insofar as mutation entries are concerned. First up, consequently, the Honorable Supreme Court allowed the appeal, directing the authorities concerned to maintain status quo insofar as the existing mutation entries are concerned without prejudice, and await the decision of the civil court in the pending suit of the year 2022. Whose next para, it is notable that in neither of the said judgments, the specific scopes of the suit and the interplay between the suit and the mutation proceeding was considered, nor was the effect of the specific provisions of the West Bengal Land Reforms Act 1955 considered. First up, in the absence of any such consideration, none of the said judgments can be said to be a binding precedent on the scope of adjudication of a civil suit versus that of a revenue officer under section 50 of the 1955 Act, read in the context of section 61 thereof. First up, next para, section 50 of the 1955 Act empowers the revenue officer empowers the prescribed authority to maintain up to date in the prescribed manner the village record of rights by incorporating therein changes on account of mutation of names as a result of transfer or inheritance, etc. First up, thus, the scope of inquiry of the prescribed authority under section 50 is in the nature of an administrative process, limited to an inquiry as to the actual possession and the transfer deeds of the parties, which is also borne out by Rule 59 of the 1991 manual, relied on by the writ petitioner. First up, it is to be noted that such exercise is merely administrative in nature and does not have any element of any judicial adjudication, contrary to the scope of a civil suit. First up, next para, in any event, the recording in the records of rights are always subject to the decree passed by a civil court conclusively determining the rights of the parties, which has also been enumerated in the judgment of the tribunal impugned before us. First up, next para, however, the question here is whether the revenue officer or the prescribed authority should stay its hands insofar as mutation is concerned merely because of the pendency of a civil suit. First up, next para, section 61 of the 1955 Act specifically debars the jurisdiction of the civil court, preceded by a non-obstante clause, from determining any question relating to any land or connected with any matter which is required to be or which has been inquired into or decided by any revenue officer or prescribed authority under the provisions of the said Act. First up, the non-obstante clause takes into account any other law for the time being in force or in any decree, judgment, decision or award of any court, tribunal or authority. First up, next para, thus, section 61 is couched in the widest possible language. First up, next para, hence, it is evident from the provisions of the 1955 Act itself that the scope of inquiry and adjudication falling within the domain of the authorities prescribed under the said act are completely different in scope from the adjudication of title in a civil suit. Full stop. Despite the decree of a civil court being conclusive in nature and binding between the parties, comma, per se the pendency of a civil suit before a competent civil court cannot operate as a bar to a proceeding falling within the exclusive domain of the authorities under the 1955 Act. Full stop. Next para. Thus, comma, mere pendency of civil suits cannot be considered to be a bar in a mutation proceeding. Full stop. In the coordinate judgment in Sohail Ahmad, comma, it was considered by the court that an order of injunction binds only the parties and not any tribunal or forum. And in any event, comma, an adjudication by the tribunal only affects the legal nature of the possession of the parties and not the nature, character, and possession of the suit property in its corporeal sense. Full stop. Next para. Also in Jitendra Singh Supra, comma, the Honorable Supreme Court categorically reiterated the well-settled principle of law that the effect of mutation that mutation of property in revenue records neither creates nor extinguishes title to the property, nor has it any presumptive value on title, and such entries are relevant only for the purpose of collecting land revenue. First of, it was further observed that so far as the title of the property is concerned, comma, it can only be decided by a competent civil court. First of, thus, comma, there is no overlap of jurisdiction of the authorities under the 1955 Act in a mutation proceeding and that of a civil court in a regular civil suit. Full stop. Next para. Coming to the next issue, comma, a question arises as to whether the status quo order passed by the civil court in the present case would operate as a bar to mutation of the name of the respond number 5 with regard to the subject property. Full stop. Next para, as rightly pointed out by learned counsel for the respond number 7, comma, it is evident from the extracts of the records of rights annexed to the writ petitions by the writ petitioner writ petitioners themselves, writ petitioner itself, that the records at present stand in the name of the erstwhile owners who have transferred the property in favor of the respondent number 5. Full stop. The erstwhile owners support the respondent number 5 and have withdrawn their suit challenging the sale deed in favor of the latter. And as such, comma, there cannot be any affectation of the rights of the plaintiff stroke writ petitioner in any manner whatsoever if the names in the records of rights are altered from that of the erstwhile owners to the current purchaser being the respond number 5. Full stop. Next para. It might have been otherwise if the alteration was sought from the name of the present petitioner to that of the respond number 5. Full stop. It being not so, comma, the alteration does not have any material bearing on the rights of the plaintiff as claimed in the suit in any event. Full stop. Next para. Secondly, comma, the status quo order was passed in respect of nature, character, and possession of the suit property. Full stop. Insofar as nature and character of the suit property in its corporeal sense is concerned, comma, as held in Sohail Ahmad Supra, comma, there would not be any material change in the event mutation is done in the name of a particular person. Full stop. It would only be relevant for the purpose of revenue collection, comma, as reiterated in Jitendra Singh Supra by the Honorable Supreme Court. Full stop. Insofar as possession is concerned, comma, possession, comma, in a status quo or injunction order passed by a civil court pertains specifically to the physical possession of the property. Full stop. Even in terms of the status quo order dated July 24, 2024, relied on so heavily by the petitioner, it was recorded that the plaintiff is merely in constructive possession of the suit plaintiff stroke petitioner is merely in constructive possession of the suit property, whereas the physical possession of the suit property lies at present with the defendant number 1 stroke present respondent number 5. Full stop. Next para. That apart, the scope of the suit filed by the petitioner cannot also be overlooked. Full stop. The primary relief sought by the plaintiff stroke petitioner in the suit is a declaration that it is an irrevocable licensee in respect of the suit property. Full stop. The other primary relief, principal relief sought is a decree for declaration that the plaintiff stroke petitioner, plaintiff stroke company is the absolute owner of the entire factory shed together with plant, machineries installed therein, lying and situated in the suit property. Full stop. Thus, the plaintiff, in the suit itself, categorically distinguishes between the rights asserted in respect of the suit property and the factory shed along with the plant and machinery installed therein. Full stop. The ownership of the plaintiff has been claimed even as per the plaintiff stroke petitioner's own version, only in respect of the factory shed and the plant and machineries installed therein, whereas with regard to the subject land, the plaintiff merely claims rights as an irrevocable licensee and not as the owner. Full stop. Thus, even if the suit reaches its logical culmination in favor of the plaintiff, the decree which could at best be obtained by the plaintiff would confer the right to an irrevocable license, pertaining to possession of the suit property and not any ownership right in respect of the same. Full stop. Next para. Hence, the ownership of the subject property of the respondent number 5 stands undisputed, be it from the perception of the erstwhile owners or the plaintiff's petitioner itself. Full stop. Accordingly, in the facts of the present case, even the final outcome of the suit would not have a material bearing insofar as the ownership of the subject property, which is an important determinant of mutation, is concerned. Full stop. Next para. Secondly, vide order dated March 15, 2023, the learned trial judge, while interpreting its previous status quo order, had categorically observed that it cannot be said that by trying to mutate his name, the defendant number 1 is violating the order of status quo. Full stop. It may be noted that the nature of the status quo order passed at that juncture was similar to the present one. Full stop. Next para. The learned trial judge, the civil court clearly elaborated that the civil court cannot pass any order upon the mutating authority to restrain it from mutating the name of any person, and even if the right of a person upon a property is established after trial and eventually he gets a decree of declaration that he is the true owner, the civil court cannot direct the BL and LRO to correct any mutation entry which is against the interest of such person. First of what the said decree holder can do is to make an application before the BL and LRO intimating the fact of the decree passed in his favor and to pray for necessary correction of the record of rights. First of the process of mutation entry, it was held, is governed by a specific statute, that is the 1955 Act, under which the revenue officer is empowered to mutate the name of a person in the records of rights. First of next para, in our view, such observations of the civil court was a perfect exposition of the law on the subject and cannot be faulted. Full stop. Hence, comma, even from the perspective of the civil court itself, comma, its status quo order would not be flouted in the event mutation was effected in respect of the suit property. Full stop. Next para. Hence, comma, the second issue has also to be decided against the petitioner inasmuch as the mere mutation of the property, comma, if ultimately effected, comma, would not uh, tantamount to violation of the status quo order passed by the civil court in any manner whatsoever. Full stop. Next para. Another aspect of the matter cannot be overlooked altogether. Full stop. The learned tribunal, comma, by the impugned judgment, comma, has correctly not directed the revenue officer to mutate the records in the name of the respondent number 5 outright, but has merely remanded the matter to the concerned BL and LRO Domjur to reconsider and process the mutation application strictly in accordance with law on the basis of the registered deeds of conveyance without being influenced by the mere pendency of civil proceedings. Full stop. Next para. In our view, comma, in the facts of the present case, comma, the said direction was the only plausible and correct direction to be passed in the circumstances of the case. Full stop. Next para. The neither the BL and LRO and neither the prescribed authority nor the appellate authority took into consideration all the facets of the matter, comma, as opposed to the learned tribunal, which took into account all the relevant facets of the matter, aspects of the matter, as well as the law governing the subject. Full stop. Thus, comma, we cannot find any fault with the impugned judgment of the tribunal. Full stop. Hence, WPLRT 52 of 2026 is dismissed on contest, thereby affirming the judgment dated February 19, 2026, passed by the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA numbers 3896 of 2023 and 3897 of 2023, bracket A, LRTT. Full stop. Next para. In view of the pendency of the writ petition till now, comma, the period of 8 weeks for the entire exercise to be completed by the BL and LRO, comma, as granted by the tribunal, is extended for a further period of 8 weeks from date. Full stop. No
And I bring more 2 weeks because of the election. 10 weeks.
10 weeks. 10 weeks from
Your
My,
Lordship.
my lord, kindly grant liberty to the petitioner if the petitioner files any application. This order may not be preclude
any application where?
before the tribunal or the BL and LRO. My lord.
No. You have been. It has been directed to be done in accordance with law.
Reconsider.
Our very premise of our judgment is that civil courts jurisdiction is different from this.
Well,
Our observations cannot affect your rights.
Well,
আচ্ছা একটা লাইন add করে দাও. It is made clear
and
that
not to create
the
any
above
third-party interest.
findings, above observations have been arrived at only for the purpose of the present adjudication and shall not affect the rights and contentions of the parties in any manner, either before the civil court or before any forum.
Not to protect a third-party interest. my lord.
Okay.
What else? The suit should be decreed. Ask your client whether the suit should be decreed.
কি বলছো?
Don't go by your client, please.
Your Lordship, please,
Affidavit of size filed to be kept under. Yes.
two things. One, at the very beginning, may I just
Yes,
take the
yes.
liberty to point out, your Lordship has referred respondent number 5 within bracket defendant number in title suit 497. It should be title suit 178 of 2014.
170, right?
178 of
2014.
24.
2014, right? And
And in one place, your Lordship has referred that the judgment of Shoaib Ahmed as of the court. No, not court. It was of this bench.
yes, that deliberately said. No, we did not say coordinate. Did we say coordinate?
Coordinate bench, your Lordship.
Coordinate means good. Coordinate means policy.
Just before the Lordship referring to Jitendra Singh.
Of a division bench of this court. Of a division bench. Thank you. Yes. সোহেল আহমেদ না কি আছে ডিভিশন হ্যাঁ ওটা ওহো দুটোই তাহলে ওই না দুটোই তো বলে দিলাম নাম্বারস বলিনি
Well, item 18 mila Gavan 17.
ওহো তাহলে নাম্বারস করে দিন WPLT numbers such and such are dismissed. The order is the same or orders are different?
Same. Common order.
Same order. Common order.
WPLT শুধু and WPLT
Different
are
number.
dismissed. আর যে অর্ডারটা আমরা অ্যাফার্ম করছি তাতে দুটো ওয়ের কথাই বলা আছে হ্যাঁ হ্যাঁ ওটা দুটো আছে শুধু WPLT অন্যটা অ্যাড হয়েছে and WPLT both are dismissed. No, common order
Common
and
WPLT.
such and such. Yes.
My lord,
WPLT number touching.
Next.
18.
document. OA document.
Yes. Yes, please hand over a copy of the photocopy of the plaint. We have referred to that.
My lord.
In the course of the day, give it for the records.
My-
Only the plaint, full plaint. The legible copy, please. উনি প্লেনটা দিলে ওটা ঢুকিয়ে দিতে হবে এটা একটা সই হয়ে গেছিল পরে কারেকশন হবে যদি পো হয়ে গেছিল উপরে ও হয়ে গেছিল ওকে দেখিয়ে নিয়ে গেল plaint right then not required thank you
Item number 19.
My lord, in this matter, I am for the.
I am for the state respondent.
My lord, in this matter.
any
my
private
lord-
respondent Mr. Mahathir
Pardon?
any private respondent involved
No. My lord, I have challenged the tribunal's order whereby, my lord, the interim order of injunction has been refused. My lord, my contention is this. My lord, the issue is, my lord, under section 5(1)(a) of the Estate Acquisition Act. My lord, just now I have,
estate ওই যে ওটা দেখা যাচ্ছে yes Mr. Mahathir
my lord, by this provision, all the hearts, bajars have been, my lord, is required to be vested. My lord, today, my lord, I have got the information that one special bench was there, and my lord, that has been decided. Also, the circular has been set aside. May I come back tomorrow?
yes
May I come back tomorrow?
I was in the matter.
do you have a copy of that right now you cannot have obviously
It is facts, my lord. In Pakua Hart case,
acha
decision was taken by the division bench.
Division bench.
No, not special bench, division bench. Ultimately, review was taken up. I was one of the party. Number of cases were there. Ultimately, it has been held that circular has been given a go by. And all the decisions taken regarding vesting of hearts under section 5.
Mr. Rai, would you be helpful
Yes,
either Mr. Rai or Mr. Rai, just the number at least so that
I shall come back, my lord.
we'll keep it on Monday then please supply a copy to your learned friend also Mr. Ghalib will supply to your learned friend for the state and Mr. Rai will give to petitioner, state to state.
I'm getting.
Thank you. Learned counsel for the petitioner submits that it has come to the notice of the learned counsel that judgment of a division bench is with regard to a relevant notification is required to be placed before this court. Proceed accordingly on the prayer of the petitioner, let the matter stand adjourned till April 6, 2026.
I'm good.
Item number 20.
Yes.
Item 20 to 26, a series of matter, my lord, I was praying for a short passover, my lord.
Out of list then. Either move the matter or out of list.
Mr. Sorojit Das Gupta, he was here.
You are here now, you move the matter. It goes out of the list. Unless you start moving the matter. Start the matter. We always give opportunity to start the matter. If you start the matter, we take up the matter. '20 to 26 should be taken up together.
Yes, my lord, these are
20 to 25.
22, 20.
ওটা দেখান দিন এটা বলতে হবে কেন What about notice to the other side?
My lord, we are moving it now today, ex parte, my lord. We have, because, my lord, what has happened in this matter, we are expecting, we are trying to have a stay of the order of the
rent controller's order, my lord, because, my lord, the reason only is because there is no stay. The respondents have filed an eviction suit against me, and in that eviction suit, already some order has been passed.
Order regarding what?
Eviction of my client, my lord.
Decree has been passed.
My lord, the matter was that the landlord, landlord, he is the subtenant of the main landlord with the authority to give on rent. Now, as per that authority, he has given rent to my client.
Yes.
And accordingly, all the other clients who are
On
there,
these matters.
all these matters, my lord. Now, after the coming of the 97 Act, my lord, he filed an application before the rent controller for fixation of fair rent.
You filed.
No, the
Landlord
filed. Now, we contested that matter before the rent controller. Our contention was that he has filed for the fixation of fair rent as per the new law, new act. But for that purpose, we objected the copy of the order of the rent controller is there. We contended that the other conditions which are necessary for for the landlord to comply are not fulfilled. The property is not.
What sort of conditions?
My lord will kindly come.
Yes.
To page. We have annexed the copy of the rent controller act. Sorry, my lord, order at page 15. Page.
What sort of?
My lord, there it is set out. There it is set out, my lord.
Right, right. Yes, please come there.
I'm reading the page, reading at page 15, my lord. The second page of the order.
Yes, yes.
The tenant opposite party has filed its written objection disputing the claim made by the landlord applicant. It is the contention of the tenant opposite party that the landlord applicant received rent from the tenant opposite party till month of March 2000, but thereafter avoided and or neglected to issue rent receipts. Although we have been continuing to pay the rent, since he failed to issue the rent receipts, we thereafter started depositing the rent with the rent controller.
Right.
Now, what we contended that the landlord who is supposed to maintain the property, he has not been maintaining, although he has been claiming maintenance from us. The corporation taxes, we don't know whether the corporation tax is being paid by the landlord. We asked for the receipts or deposit before the corporation tax. Our entries before the corporation that we have been entered as a tenant, we are giving nothing has been provided, not even the agreement between the original landlord and him, that on what terms and condition he has taken the rent, so that according to that agreement, we can consider the enhancement of the tenancy agreement or the new rent. All these things we had contended before the rent controller.
But you are duty bound under 7 and 8, 5.
My lord, we are not.
You are concerned. You are not bothered with that, irrespective of his obligations.
No, my lord,
to comply with this.
Obviously, we are not contesting on that. Our contention is that now he is charging us corporation on account of corporation tax. Whether he is depositing with the corporation, whether our name is entered with the corporation or not, tomorrow a notice suddenly comes that this much amount
cannot be a consideration for fair rent fixation. Why? How can that be let us see section 20. How can that be a consideration in section 20 fixation? Where a landlord intends to increase rent, he shall give rent. The increase of rent shall be due and recovered from the month of. Now that should be governed by the other provisions. Fixation of fair rent.
Section 17, my lord.
17. Right.
The controller shall, on application made to him either by the landlord or by the tenant in the prescribed manner, fix the fair rent in respect of any premises in accordance with the provisions of this act. The fair rent
made a section 17 application before the controller.
Yes, my lord.
Yes. Fair and these yardsticks are to be taken, but what you are saying, show us from section 17 that those yardsticks are also there. Whether he is paying to the corporation or this, you may have other remedies for that. You may have other remedies for that. If he is not paying, corporation notice is issued. There may be other remedies, but whether those are germane for adjudication of fair end. Show us from these provisions of section 17 that any of these are germane considerations for fixation of fair end. Show us that. The age of the tenancy is to be seen.
Yes,
Other
my
things
lord,
have been-
we are not contesting on that. We have
Then
no,
what happened? Fair rent was fixed by this.
fair rent was fixed by that. We were
You have
aggrieved.
challenged that before the
We
tribunal.
we were aggrieved by that order. We challenged that order before the.
Here you ask for what stay? Stay of what?
We, my lord, will kindly come to. We had prayed for stay of the order of the rent controller.
What is the pressing urgency that you need not serve a copy on the other side? Why should it be stayed?
My lord, only reason because for not serving this, because of the filing of the eviction suit against my client, and orders have been passed.
Eviction suit was filed when? After this?
After this, my lord. After passing of the order by the
rent controller.
Yes, my lord. Not rent control of appellate authority, my lord.
As appellate authority.
That order is at page number 19. The what happened, my lord, the appellate authority held.
Appellate authority means the tribunal.
Yes, my lord. The tribunal, in the tribunal, we filed an appeal. In the appeal, we also filed a stay petition. So, on the first date, the stay of the hearing of the stay application, my lord, the tribunal held that we will hear out your stay petition, but in the meantime, at least you to show your bona fides, you deposit 50% of the rent that has been fixed.
What was the previous rent you are paying?
Rupees 175.
And now what is the fair rent fixed?
Fair rent fixed is 1085.
Now, what is your pressing urgency? What has been done? Eviction suit has been filed.
Yes, my lord.
When?
My lord, eviction suit, my lord, the exact date.
Exact date. After this order?
After the tribunal's order, my lord.
So
after
then
this
what is that? The eviction suit will take years to be disposed of.
My lord, but they are pressing hard with the eviction suit. They have issued notices against my client, my lord. I was only praying, my lord.
Eviction suit has been filed. You go and file a written statement there. How
my lord,
why should you have a stay of
that we have already done. We have taken all steps before the before this in the eviction suit. But my lord, because the stay is not there with the tribunal. Now they are not taking any step for hearing of the appeal because they are there, my lord. The direction was given for filing of objection in
What is the urgency for not serving notice on the other side of this writ petition? We don't understand at all. You have challenged before the tribunal. You have challenged fixation of fair rent.
Yes,
you asked for stay. Stay has not been granted. You have challenged that in the present writ petition. Now, an eviction suit has been filed. Where you have filed a written statement, you are contesting that.
Yes, ma'am.
So, what does that have to do with this? You should serve notice and come. Serve notice to the other side.
Very well, my lord. A short direction, my lord. We will serve.
How soon can you serve?
My lord, if it has to be served by hand, my lord, we can serve.
No hand business.
Then, my lord, within 2 weeks, because it has to go by post.
Legs of the postal peon. Hare Street and British Indian Street. We will keep it after
2 weeks.
2 weeks.
But in the meantime, my lord, only prayer, my lord, to consider, my lord, no coercive step in the ejectment suit, my lord.
No, absolutely coercive steps will be taken against you.
My lord,
We can direct that this will not.
my lord,
this
because
will not prevent the
already I am
eviction.
out of pocket by 50% of the rent that has been fixed, my lord.
More out of pocket by the time the eviction suit is over.
My lord, will you kindly allow me to
You
sorry.
tell him what you have said. You tell him what you have said. Stop and come back. There is no pressing urgency. The present challenge has been preferred against an order whereby the West Bengal Land Reforms and Tenancy Tribunal, in an appeal against fixation of fair rent by the rent controller, refused to grant stay of such order. Full stop. Learned counsel for the petitioner submits that the writ petition is being moved without notice due to the extreme urgency, since an eviction suit has been levied against the petitioner. Full stop. However, we do not find the filing of an eviction suit simpliciter to be a sufficient reason for waiving prior service of notice of the writ petition on the respondent. Full stop. Accordingly, the petitioner in each of the matters are directed to serve notice on the respondents, indicating that the writ petitioners shall be listed together next on April 13, 2026. 13th April.
13th April.
13th.
My lord, the ejectment suit has been filed
And
in
file an
January.
affidavit of service on the said date.
Ejectment suit has been filed by the respondent, my lord, in January.
You have years to come. Common order. ওহো আজকে তো আলাদা আলাদা কেউ আজকে কি কমন অর্ডার করা যায় আপলোড হবে করো কমন করো
But upon
we are
instruction,
making it a common order so that your client will be less out of pocket.
lesser copies.
Yes, not so easy to kill an advocate order. Very difficult. Even wild animals fear us. Persons connected with the judicial system. Yes. You're saying something? Sorry, you're saying
I
something?
was only upon instruction making a prayer.
You have all proceeding the eviction suit.
That can't happen. But in the meantime, not to give effect to the rent controller order. Fair and not to give till such time.
Number 26.
We are doubtful whether we should have admitted this also.
26 this one,
But because you are not there, probably that was one of the reasons because he did his level best.
kindly
He'll
not do that. But on the next day, kindly not do that.
We'll forget this.
In this matter, I am.
No time. Move the matter.
Not,
No, refuse. Move the matter. Otherwise, it goes out of the list. Yes. Standing.
In this matter, his leg on code number 30. 30 রথ আছে এটা সুজিত রথ appearing for the petition. He is on leg.
Who is on leg? Who is appearing?
সুজিত রথ.
Sujit Roth.
Yes.
Oh, no, we are putting matters out of the list if people are not coming.
No, only not to.
Others have suffered. Why should you be in a privileged position? No. An adjournment is sought in the matter. Let the matter go out of the list. Next.
Only not to them.
Please give your name.
Yes.
Mr. Banerjee, give your name also. Yes. 27.
My lord, I am for the appellant. My lord, I am praying for
Petitioner, not appellant.
petitioner.
Yes.
I am praying for an adjournment
No.
for 1 week. My lord,
Will go out of the list. Start the matter.
my lord, actually supplementary affidavit is yet to be filed.
Forget those excuses. We know those excuses. Move the matter. It's before you file. It's before you move the matter.
My
What's
lord,
the
the
matter
advocate on record is not present today.
You are of the same chamber.
My lord, but I was
Then you
not
have to be ready in the matter. Otherwise, it goes out of the list. And this is the last chance.
kindly.
Move the matter right now, or it goes out of the list.
My lord, kindly.
On an adjournment is sought by the petitioner. Let the matter go out of the list. Next. যটা বেরোচ্ছে একটু মনে করে দেবেন ততগুলো ঢোকাবো yes
বলছে মৃণাল বাবু
সেম ফেড টাইম চাইলে গেল
না টাইম চাইবো
yes Mr. Basu Malik, same order.
No.
We'll take this matter up to 4:30. Both of you are there.
No.
Both of you are there.
Don't do that. Today, Lordship.
Vengeance of the court.
my lord wants very right rightly said vengeance
Sadistic, utterly sadistic.
my lord was with me on other
Because
days
you and Mr. Basu Malik are
my
there.
lord was with us on other days
We were different then.
oh
Now we have become different. We have come to a different place. Obviously, when I was with you, I was like you. I have come here, I have become like my brothers and sisters. So that's very easy to understand, sir.
Change.
These changes happen.
I have to accept.
What is the challenge against Mr. Bosu? You are leading Mr. Bosu only. Nothing in your matter. And you are appearing in person on the other side.
Sir, I am Suman Gupta, respondent number 3.
Acha.
In person.
You have not filed any wakalatnama through any advocate.
In person appear.
Very, yes.
Very short point.
You have no point.
In thicker tendency matter, 3 ingredients has to be fulfilled. Application, or letting of a land.
May I come back tomorrow with this matter?
Why?
What can I have?
Lordship,
Not
I
right.
have some prayer.
Yeah.
If you give me permission,
May I indicate the point where you want to candidate? So that it is easier for him also.
No, you are the respondent. They have to.
going into the merit, first of all decide the suit is maintainable or not, because
Not suit, read petition.
writ petition is maintainable or not, because applicant is come before this court not clean hand. He suppressed the vital material fact. If you give me permission, then I
So
will.
that you when you make your arguments, you make out this point. Yes, Mr. Avach.
The point is very simple. Under section 3(5), first vacant land has to be laid out
Yes.
with the right to construct, and the construction is kacha.
Yes.
This don't do, my lord. I need not say. If
The 2010 Pakka, this concept.
Pakka am not coming. Pakka, in this case, my lord, Pakka constructed thereafter. That I cannot deny. So first of all, my lord,
Now, what have you challenged here first, Mr. Vasu?
the Thika controller hold that this is a Thika land, and that has been affirmed by the tribunal. Against that, I am before my lord. And the building is, my lord, today building is Paradharpal. But I don't say that I am trying to prejudice, my lord. But I want to show to lordship the
No, what would be your main point, Mr. Vasu?
main point is this cannot be a Thika, but the ingredient of Thika is not there.
What is the nature of suppression? Let us hear him on the, because if we'll ascertain whether affidavits are required, that's right.
We'll look to page 31 once thereafter kali hearing.
Very good. 31, let us see.
Something color ছবি আছে বাবা
But we don't know whether this has been, when was this build constructed?
today this is the situation, I say. Today this is the situation. Now it has been declared that it is a Thika land.
Sir, this is AI generated photo.
Well, can you send somebody? Now, whatever my lord will say, AI
Not
generated.
the real position there.
No,
There is no building.
already vacant building. Report is already submitted before the.
Building is there or not?
Building is there,
That
but
I'm
photo
showing.
is AI generated photo.
Oh,
Pardon me, my lord.
No, photo
I
is
don't know
photo,
how it.
Just like a mall. But there is nothing else.
very modern building.
Yes, but there is nothing else.
No modern building.
Nothing as such. Please file your affidavits.
Income-
We require
income
affidavits in
building.
this. Fit case for affidavits. You disclose all the facts. At the present challenge has been preferred against an adjudication whereby the subject property has been held to be a Thika tenancy property. So, sub next para, you are respondent number
3.
The respondent number 3, comma, appearing in person with the leave of court, comma, submits that there has been material suppression of facts by the petitioner. For sub next para, in order to bring to light all the relevant circumstances of the case and the factual versions of the parties, comma, the respondents are directed to file their affidavits in opposition within what will be a reasonable time, you and Mr. Gali, for filing affidavit? 2 weeks? What 4 weeks?
3 weeks, 3 weeks.
Let us bargain a bit more.
No, no.
You can do it within 2 weeks. Within 3 weeks. State within 3 weeks first from date.
Against me. Everything is against me.
Everything is against you always. Reply, if any, shall be filed
Otherwise, you will not say anything in my favor. That I
within
also know.
a week thereafter. Full stop. The matter shall be listed for hearing in the monthly list of May 2026.
And in the meantime,
What sort of
declaration, my lord, no effect, no coercive steps has to be taken.
what coercive step? Will,
Because the building constructed, that is in my possession till today.
what coercive step?
Because the trade may try to oust me. That should not be till my lord is hearing.
Bare apprehension, Mr.
Yes,
Basu.
bare apprehension.
We'll record a line that at present, we do not find any reason for passing any impugned.
At this stage,
any,
I will
at
pass
this
up.
stage, you will say that,
Well,
and will give the parties liberty to approach the court if any interim order is necessary.
Before passing any interim order.
We are not passing an interim order.
Before that,
At this stage, comma, we do not find any urgency to pass any interim order. For sub next para, however, comma, the parties will be at liberty to approach this court with an application in the event any exigent circumstances requiring interim orders arises. প্রথমেই affidavit is filed to be kept
Your
on
Lordship is admitting it. I will show to your Lordship one paragraph. I think that will be beneficial for ourselves to see this cannot be an. But kindly take trouble to the impugned order, page 9. Darling page 289.
You will forget, we will forget what is there.
And once for your Lordship satisfaction. Kindly come to paragraph 37. The finding.
This is page impugned order.
289, internal page 9. Volume 2.
Yes.
I'm reading for my lord. The
Yes.
controller's conclusion that tenancy originated with the Kacha structure. Nothing more I to say. If the tenancy commenced with the structure, then cannot be any tika.
Yes. Let us come back.
Yes.
Grateful.
So my lord has admitted it without looking into anything. That's why I want to satisfy myself that something is there.
Grateful.
Item number 29.
The function will be at 4.
Yes, why?
Nothing. I just want to communicate to my lord.
Vasu, this is unfair on the judges. Very unfair on the judges. You cannot. And Mr. Vasu, I want to point out something else. Including my learned brother judge, at least 50% of the judges have not been invited by the bar.
I have heard that. I've scolded them that official.
I was seriously thinking whether I should go there. Not because of any other reason, for the purpose of propriety. Because I am a member, special member of the bar. I take serious exception.
This reached to me on the morning.
Why you could have done it a day after?
And I am not official, but the moment it
I was
came to my
embarrassed
knowledge,
for umpteen number of times. So many judges I asked, they don't even know.
I'm sorry, my lord. Accepting the.
So it would not
expressing
be
sorry, my
proper
lord.
for us to go and.
Absolutely correct. In the morning, I have an altercation with the secretary. What is this? No,
nobody came to most of the judges.
I have
Nothing
no
was-
justification.
Nothing was circulated also.
I have no
There could have been a circulation given to the Chief Justice Secretary.
We are persons that we can go and meet the judges and
And
say.
this never happens with the other bar programs. I'm telling you.
And this also.
Never happens.
No,
Because
this-
we are invited to Bar Library Club recently. For
Those-
same photo unveiling.
My lord, kindly recall.
From wrong back. All judges.
I can say to Justice Sobhasaji Bhattacharya, have you ever seen this in our library ever prior to this incident?
Up to 8 years back, I can't say no. I did not see. Last 8 years, I don't know.
Whenever I
Yes, sometimes it happens.
I look after.
Once a card was almost thrown to me. I won't name the person. Not a raw junior, a lady, but not a raw junior. Almost, if you want to come type attitude. So, not that it's not happening. It's been happening for years now.
My lord, that I cannot
Years
justify.
now.
I will not justify, but today in the morning, can you take it from Mr. Basu that
We
I
cannot
had this
imagine half
discussion.
the judges not being invited. At least they should have been invited.
Certainly. Well, had it been known to me yesterday, I also go to the judge's chamber. I personally.
You
In the
say that
morning
all
I
the
came
time,
to
you do nothing.
Sorry, my lord.
You will definitely have not gone personally.
I should have, if this is the situation. I have no ego.
Probably if you knew, you would have done it.
I have no ego. I'm sorry, my lord. I accepting the expression.
No.
Sorry, my lord. I cannot say anything.
No, you should express your apologies to the judges who have not been invited. Even post facto, sir.
Sorry, my lord. I will think. My lord.
You just think what should. I mean, it's very bad. It leaves
Very
a bad
bad.
taste in the mouth.
In the morning,
Photo unveiling of the Bar Association, largest association of the court.
why so hurry? I mean, that has also.
Only a few judges have been.
I know. Don't repeat, my lord. I
And
know.
I
Don't
would
embarrass me.
not name them so that will be more embarrassing.
Embarrass me. Don't embarrass me, my lord. I
Absolutely
know.
partisan approach.
I know.
That's why you should take matters after 4:30.
Don't punish for that. Well, be there.
Some punishment should not be there,
Be
Mr.
there.
Vasu.
No,
You are saying that it should be punished.
Be there, my lord.
His lordship is always with
Supreme
us.
Court says also kindly be there.
We are paying apology.
Bar in the English sense, not in the Bengali sense, Mr.
No, I'm not saying anything, my lord. I have also faced this situation.
You know that does not happen in this court.
No. Actually, when he was secretary, in every incident, he had to talk to me. But he also, but for the first time, I find
No,
it is not known to me.
I can't recollect any such incidents. Incident during his.
No.
I can't recollect.
For the first time.
Yes. In that 10-year, my lordship, remember, if not, my lord, the person.
Although it was the worst tenure of the bar association, but
No, no.
this did not happen.
No.
I agree.
This did not happen.
I agree.
Carrot and stick policy.
I agree. Chal.
Occasionally carrot. For Mr. Basu. Yes, what is the matter? Mr. Giri.
Expeditious.
Disposal of the
Delay on mutual delay before the tribunal.
MAs are, what are the MAs? MAs are
Yes. One MA section.
Those are also pending.
No.
Those
MA 808 of 2020 was substitution disposed of. Now, my lord, MA.
Application for condemnation delay, both the application are pending. Your lordship kindly direct to dispose of the matter.
No, but if you are.
The proceeding was started in the year 2015.
But you are.
Challenge the year 2022. My lord, the tribunal, my lord, it is very unfortunate situation. Tribunal giving the date to only this matter. Other matter, 6 months, 7 months, 8 months.
Why is it happening? I mean, the tribunal is not fully manned. Probably there is a shortage of people.
Total member is there.
Total member is there. Acha, what happened on 28th of January? That was the last date fixed. So you haven't taken any certificate?
28th July 2026. Next date, last.
8 July.
8th July is the next.
28th July.
25.
Oh, acha.
Paucity of time, the matters can adjourn.
No, car. Acha, you complete first, I'll tell.
I didn't dispose. I
No, no,
any interim order. Only a direction to dispose of the matter without giving.
Excellent argument, Mr. Giri. But the last order annexed is 8th of July. The next date is 28th of January 2026. We are in.
Last page of the brief, lordship. Last page of the brief. Before the back sheet.
I am not favored with any other.
20th January.
I am favored with only this. This is the last certificate copy.
Dated 20th January order.
8th July 2025.
After
next.
January.
After that, there is Vakalatnama in my book. And then power of attorney. Photocopy is there. Photocopy is there, yes. But certificate copy is not there. Anyway, 28th July. The prayer of the petitioner.
There is one story in between, Lord.
What is that?
Learned friend has prayed for a liberty to file supplementary affidavit in 2025. He himself has prayed for supplementary affidavit. So that is page 12.
I have filed it and I have served the copy.
That is.
Yes, what else, Mr. Gali?
Service is yet to be completed. Last order shows that page 18. Kindly see page 18 order. Last order is of 28th January, Lordship, page 1818. That supply service on the last order sheet is yet to be completed. That is one. Page 18. This supplementary affidavit which he took the liberty in 2025. I am at minute way of 2020 you are telling. So this is yet to be completed. And point number 2, state I find has filed opposition to section 5. Section 5 is MA 921. He is yet to file reply.
Then why should we favor you with an order?
I am saying, supplementary affidavit, my lord, I have served upon the landed government representative.
28th January order records that you are directed to cause service.
That day at evening and afternoon, I have served.
Then you are saying.
What I would reply to the opposition?
Finally reply till date.
You will not use.
I have not used this.
We'll record that.
Yes. On record, it will be disposed of.
The present application has been filed for expeditious disposal of 082630 of 2022 within bracket LRTT and the connected pending applications, which are now pending before the 4th bench of the West Bengal Land Reforms and Tenancy Tribunal. For next para, learned senior government advocate points out that a supplementary affidavit filed sought to be filed by the petitioner has not been served even as per the last recorded order, comma, on the state, comma, nor has the petitioner filed any affidavit of service, not has the petitioner filed any affidavit in reply to the opposition filed by the state to the condonation application of the petitioner. Puts up learned counsel, learned counsel for the writ petitioner submits that the writ petitioner shall not file any reply to the opposition filed against the condonation application and proceed on the basis of the materials already on record to argue the condonation application. So it is further submitted that a copy of the supplemented affidavit has been served on the state in the meantime. Next para, be that as it may, comma, we find that the original application and the connected pending applications are pending since the year 2022 and that long dates are being fixed in the matter. Accordingly, this court is of the opinion that the matter should be heard out expeditiously. Hence, WPLRT 66 of 2026 is disposed of by requesting the fourth bench, West Bengal Land Reforms and Tenancy Tribunal to dispose of all pending applications in connection with OA 2630 of 2022 within bracket LRTT bracket closed as expeditiously as possible, positively within 2 months from the date of communication of this order to the tribunal. Next para, it is expected that the main original application itself shall be disposed of as expeditiously thereafter as possible, positively by the end of this year. No orders to cause urgent settlement.
There is section 5.
The original application যেখানে বললাম shall be disposed of course, subject to the outcome of the condonation application.
And the supplementary affidavit opposition, if the state wants to use, they can.
That will not. Why should
he says that we have already served copy, but
use that. Who prevents you? Who prevents you? Who prevents you?
Apex court judgment, my lord, regarding the
next. Yes, Mr. Court.
May I first read the order of the Honorable Supreme Court as to what is the direction given by the
Mr. Court, can you please help Mr. Court to have the microphone? No, the other mic.
I'm sorry, Miller.
Other mic. You have to come a bit closer, otherwise it will be stretching your. Yes.
Miller, this application has been taken out.
Yes.
Pursuant to direction of the Supreme Court of India, by which the court directed this court to decide as to who should represent the late Fateh Ali Mirza.
Before the tribunal?
No. Oh, I see. I'm sorry, Miller. My apologies.
No difficulty. That's why both the parties were equally stunned.
Yes. It's fine.
I was saying.
No, sir. Please take your seat. Yes.
Malad, this writ petition has been, Malad, actually, one application was made before the land controller.
Mr. Dev, please take your seat. Yes. Rent controller, yes.
Rent controller, Thika controller.
You filed it.
My client filed to cancel the order of vesting of his land which was vested in the year 1997.
Thika controller. Cancelling vesting.
Well, order was passed. Kindly
controller. What does the Thika controller have to have with vesting?
My lord, kindly come to the order of impugned order once.
You're sure you're not confusing with some other matter?
No. Impugned order.
Acha, yes. Yes, Thika controller.
My lord, the checkered history has been stated here. Your lordship can find. I'm reading for your lordship. Checkered history, my lord, this
history cannot be checkered. Within 2 paragraphs, if the history is over, it cannot be checkered.
Well, this has been. Lordship can find the.
Let us see. Yes.
Checker's history of this case is a controller of the Kolkata Thika tenancy passed an order against the present petitioners on 29/10/1997, and challenging that order, the petitioners have filed a way 3379/2012 after about 15 years. Surprisingly, at the time of filing of the way, they did not file the MA being number such and such. In the way, the petitioners annexed Xerox copy of certified copy of the impugned order, which was issued on such and such. Actually, this appeal application way was filed after 15 years, along with an section 5. But this, due to non-satisfactory explanation, well, according to Thika controller, non-satisfactory explanation, the application was rejected. Now, my lord, against that, my lord, we have come before the honorable court. My lord, order of the Thika controller was challenged before the West Bengal Land Reforms and Tenancy Tribunal, along with the section 5. This section 5 was rejected. We come before the honorable court.
What is the ground?
My lord, ground is that, my lord, unfortunately, so actually this may change me, right? And I have found, my lord.
Ground.
Yes, my lord. No. My lord.
We are not bothered with change of advocate.
No, yes, sir.
What is your What
no,
is
no,
your litigant doing?
Just I'm saying, my lord. After going through the brief, I found one section 5 application has not been annexed. Unfortunately.
We dismiss this on that ground.
No, my lord, kindly give me an opportunity to file a supplementary affidavit. I'm just keep it next week.
You have got a copy of the section 5.
But I have nothing.
How could you draft this?
I have to collect it. My lord, kindly give me a 1 week time. Kindly give me 1 week time. 1 week time. When I'm coming with the application.
Put it out of the list, and whenever you find that application, prepare your supplementary.
Give me 1 week time. Lord, it has not been annexed, unfortunately. My lord, ground is that, my lord, I was not aware. I'm submitting.
When were you briefed?
My lord.
When were you briefed?
I was briefed some days before.
Some days before, you did not know that, you did not go through the brief to see that the section 5 was not.
But I have seen, but without.
Why don't you have a copy of the section 5 now?
Well,
it's a lame excuse. No, sorry, it goes.
I'm submitting. The ground was that, my lord, that I was not.
Why don't you have a copy of the section 5 if you are briefed a few days back?
That doesn't mean not be handed over to me. But unfortunately, I'm submitting.
Everything is unfortunate. Let this meet with an unfortunate.
But I'm submitting. But it was.
Let us go through the order.
Yes.
Everything is in the order.
Yes.
Yes. That it appears to be so. It appears to be so. It has your case has been narrated here also. Let us see from here. Please place this order. Read this order. Impugned order. From checkered history onwards.
Checkered history of this case is that Controller Kolkata Thika Tenancy passed an order against the present petitioners on 29/10/1997, and challenging that order, the petitioners have filed OA number 3379 of 2012 after about 15 years. Surprisingly, at the time of filing the OA, they did not file the MA being number 179 of 2013. In the way, the petitioners annexed Xerox copy of certified copy of the impugned order, which was issued on 11/1/1998. In the way, petitioners have stated that the application is not barred by limitation as prescribed under Section 10 of WBLRTT Act. There is no cogent explanation in the way as to how the said appeal challenging the order dated 29/10/1997 was not barred by limitation on 11/10/2012. When the original application was filed, there is no explanation of annexing Xerox copy of certified copy of impugned order dated 2019/1997, which was issued on 11/1/1998. Subsequently, in MA 179/2013, a story has been made out in paragraphs 8, 9, 10, and 11 in order to give an explanation stating inter alia that the facts of illegal vesting was not within the knowledge of the petitioners till 15/3/11. This is my case, my lord. We are surprised that in paragraphs number 10 and 11, petitioners made out a story that when they went to lodge a GD entry on 8/6/2012, the officer of the police station handed
There is
over.
nothing in your case. What police officer gave you hand?
Well, this is the fact.
You are served with a notice of the Thika controller proceeding. And you have produced a
Well,
Xerox copy which was allegedly handed over to you by the police officer, which was of 18th of June 1996. Now, the tribunal observes that the copy which has been annexed, that copy has been annexed, that was issued on 11th of January 1998, 2 years after it was allegedly handed over to you by the police.
My lord, previously
Decide your costs. How much cost should you impose on you, on your client? It's just a quantum of the costs. This is absolutely abuse of process of court. Absolute abuse of process of court.
my lord, actually on the first occasion, the one Bhajan Kumar, my lord, I'm coming.
What Bhajan Kumar? This is your entire case that has been narrated by the tribunal, sir.
My lord, just one thing I want to place before your lordship.
Yes.
Tribunal also, my lord, cost.
For cost was given?
Yes, my lord, 10,000.
Only 10,000. High Court has to be as a status.
Don't be too harsh. My lord. Lady come people also don't. So I'm telling my lord.
Lady, so what?
No, but actually she was not aware about this.
Don't say lady, gents.
No.
And this is not a toilet speaking about.
All the matters was not aware to.
How is a lady different from a man?
Well, no.
As far as costs, there is a difference. Otherwise, there is equality. We believe in equality. If cost for gentlemen, then cost for ladies also. ₹10,000 cost. Yes, we are confining ourselves to that. What were you placing?
Well, I page press my lord, kindly come to page number 41.
You are not even ready in the matter. You should be on your toes in this sort of a matter.
This is my application. That was my application before the learned Thika controller. My lord, kindly see. My lord, kindly come to page number 42, paragraph 4.
What is this?
My lord, actually, why I'm saying why I
What
got
is this application?
this
What is
application for. No, this is application for recalling the order of.
This is the main application.
The main application.
You have annexed this, but you have not annexed the section 5.
Unfortunately, it has
What
not
unfortunately?
been done. It has not been done.
So how can you look into this if the section 5 you cannot cross the threshold stage?
Well, actually, what is the fact of the section 5 that you lordship can find from here? My lord, actually one registered lease deed dated 10/11/1989. 1989 was executed.
You are aged 72 years.
You know.
Say that. We will not increase the cost. 72 years, 10,000 rupees. She has already sufficiently suffered in the hands of her agents before the.
But this.
Probably you are also doing it without any fees. It appears to be so. No costs, but this.
No, not my lord. Kindly give me an opportunity to be heard, my lord. Before the
The present challenge has been preferred by the petitioner against an order whereby the petitioner's application for condonation of delay in preferring OA 3379 of 2012 has been dismissed. For sub next para, the matter emanates from a challenge sought to be preferred by the writ petitioner against an order dated October 29, 1997, passed by the Thika Tenancy Controller. Full stop. Next para. Such application, for recall of the said order, however, was filed about 15 years after the passing of the same in the year 2012. Full stop. Next para. In the accompanying condonation application bearing MA 179 of 2013, a photocopy of a certified copy of the impugned order was annexed, which was issued on January 11, 1998. For sub next para, however, in the condonation application, the writ petitioner pleaded that when she went to lodge a general diary entry on June 8, 2012, the officer of the local police station handed over such photocopy dated of the such photocopy of the order dated June 18, 1996, and the officer allegedly advised the writ petitioner to contact the Thika controller for vacating the ex parte order. Full stop. The learned tribunal, in the impugned order, disbelieved such contention of the writ petitioner on the ground that if the police officer handed over such photocopy on June 8, 2012, and the order and the photocopy was of June 18, 1996, the same could not have been issued on January 11, 1998, that is 2 years after the alleged date. Full stop. Next para. More importantly, the said statement of the writ petitioner was belied by the fact that notice of the proceeding before the Thika controller was duly served on the writ petitioner in the eye of law, since the attempted service returned as refused. Full stop. Next para.
Here, I wanted to show at page number 43 that previously one Bhajan Kumar Ghosh was at the position. Thereafter, the lease deed has been issued in my favor. I came in the picture very later. That is why it was not within my knowledge.
Next para. Although learned counsel for the writ petitioner submits that previously one Bhajan Kumar Ghosh was in possession of the property and the writ petitioner came into the picture much later, such averment, such submission, even if true, cannot come to the aid of the writ petitioner, since in the event the writ petitioner was not in possession of the property at the relevant juncture, she could not have any direct knowledge as to whether notice of the Thika controller proceedings was at all served at the concerned premises or not. Full stop. Next para. Thus, in any event, the long delay of 15 years in preferring a challenge before the Thika controller remained unexplained. Full stop. Accordingly, we do not find any infirmity or illegality in the order of the impugned order of the tribunal rejecting the condonation application with cost of rupees 10,000 to be paid to the welfare fund of the local bar association. Full stop. Accordingly, WP LRT 63 of 2022 is dismissed on contest without any orders to cost, thereby affirming the impugned order dated August 3, 2021, passed in MA 179 of 2023, MA 179 of 2013, filed in connection with OA 3379 of 2012, bracket A, LRTT, bracket closed, urgent certificate.
Number 31.
I am for the appellant.
Yes. Yes, Mr. Adhikari, what is
We
it?
are opposing the application for addition of party made by the my learned.
The union of India state.
আমার সুপ্রিম কোর্টের অর্ডার একবার দেবেন
আপনার কাছে এই নাই
আমার ব্রিফটা আনিনি আচ্ছা দিন
আমাদের সার্ভিসেস
সার্ভিস করেছি সবাই
কাইন্ড নাই হয়েছে I don't know.
হয়েছে
We don't have.
Can 640 is the addition of party application? Can 640?
Yes, my lord, my application is for addition being added as a party. Order 1 Rule 10.
You have filed an independent application, and
Yes, my lord.
Ms. Alam, you have also filed an.
Lordship, no, I don't. I was asking for a copy of that. I don't have. Union of it.
My lord, I don't have a copy now, but I can serve a copy of it on a.
Let's have a copy.
Would your lordship take it up tomorrow, my lord? I'll serve it.
Then I'll have a copy.
Better. Please ensure, ask your learned juniors to ensure whether copies have been circulated.
Very well. my
Even
lord,
if
I will
served,
see-
please give another copy so that
No, it's.
I will, my lord, if it is not.
it trans
Sweet with that, it is.
it transpires that the learned advocate for the Union of India is not equipped with a copy of the application bearing can 9 of 2018, bracket old can 640 of 2018, bracket close. Accordingly, learned counsel for the learned advocate and record for the appellant is requested to serve a copy thereof on his counterpart appearing for the Union of India during the course of the day, full stop. Let the matter stand over.
Tomorrow, my lord, your lordship, I don't know, it's already 4 o'clock.
Stand over till tomorrow? Not tomorrow. Oh, you are saying, then we'll keep it on Monday?
Very well.
Stand over till April 6, 2026.
My lord, regarding the cause title,
yes,
my lord, in view of the order of the Honorable Supreme Court, my lord, your lordship was pleased to pass an order
Yes.
on, my lord, 22nd December 2025 to
Yes.
amend the cause title, my lord. But it is appearing in the old cause title, Soyad Fateh Ali.
My lord, Supreme Court has directed this court to decide as to who should be.
That has been decided long ago.
That has not been decided.
Yes.
Mr. Dear, can you just hand over a copy of, can you ask him, please hand over a copy of that order dated
22nd
December 2025?
Yes.
No, not to us, to Mr. Cord and Ms. Alam.
I'm grateful to.
Please go through these also, Mr. Cord and Ms. Alam, if you have.
Lordship, I was.
Because the cause title should be amended. We submit, my lord.
There was a
Whom
direction.
did you direct the cause title to amend the cause title?
It has already been amended by your lordship's order.
In the list?
Yes.
List
List should be amended, madam.
Thank you very much. We'll immediately
Okay.
see to it. আজকেই এটা কারেক্ট করে পাঠিয়ে দেব।
ওনাকে দিতে হবে চাই কি
চাই চলো আছে আপনার
সার্ভার থেকেও পেয়ে যাবেন তাতে নেই
Yes, yes, we'll get it from the server also.
very well
my lord, kindly allow that amendment in the cause title, madam. Otherwise it is appearing in the wrong name.
It's
In the
appearing
in the
wrong
list.
pattern.
In the
No,
list.
no, we have already passed our order. It will be corrected.
Yes.
It does not require a further order by us. We don't have control over publication in the list.
CIS.
But the CIS, yes. Mr. Basu knows this technical. That is the limit of his technical knowledge.
They do not hear, my lords.
What?
They proceed according to their own whims.
Who they?
They CIS.
Absolutely. Yes, fully. They don't listen to our officers, to us.
No. Restoration application.
Within time, Mr. Basu.
Yes.
Engage in some other code. What is the reason? Formally, you must say.
Miss the list. Paragraph 4 to 6.
Application টা তো পেতে হবে। Can 4.
Can 4. Can 4.
Can
Yeah. In view of sufficient explanation for the absence of the writ petitioners of the appellants on the relevant date having been made out, comma, can 4 of 2023 is allowed, comma, thereby recalling the order dated August 31, 2023, passed in FMA 2355 of 2015 and restoring the said appeal to its original file and number. Was any interim order there subsisting at that point of time? There is no scope of the revival of any.
Can I pray any date for the main
Affidavit
back?
service file to be kept on record. The writ petition itself.
Possible. This is the
The appeal. Appeal is ready for hearing.
Read appeal one ready for hearing. Paperwork has been filed, that is ready.
May monthly list.
Any time source, my lord.
Let the appeal be listed for hearing in the monthly list of May 2026. In any event, April's 2 weeks, I won't be there, Port Blair. So, therefore, in any event, it won't be taken up. So, let it appear in the monthly list of May.
It is 4. It is 4.
Order to recall current.
I will request your lordship to.
We are recalling the order. After 3:30, all orders are bad.
No. I have not said that. It is 4.
It will not start in 4. At 4.
4:50, my lord will rise, go, and Justice Bhattacharya kindly be. Justice Supreme Bhattacharya kindly be there.
No, definitely
On
not.
behalf of the bar,
I'll ask him not to. No, sir.
This is a fault, my lord.
Some other difficulty.
My lord
He's not like me, egoistic. He's not like that. He's very friendly and.
My lord shown these things. They actually is not. May I leave?
Yes. Next matter to call.
Actually, I am the
Yes,
petitioner.
Mr. Ghosh.
This is the restoration application. Mr. Mahato is appearing for the one the respondent. Also.
What is the application for?
The restoration application. But I have served the copy of the restoration application.
That is sufficient. You filed within time.
No, that is one of the delays there.
How much delay?
180 days.
180 days. Can 3 is that condonation application?
Can 3 is a section 5 condonation, my lord. And
Section
can
5 regarding this restoration. Very well. Since none appears for the state at the time of call, let the matter stand adjourned for the day.
Lawsuit, I am
Yes,
appearing
Mr.
the
Das.
appellant petitioner lawsuit.
For the first time?
No, lawsuit already first time already served lawsuit.
Served.
Yes, lawsuit.
Then let us adjourn it for the day. You have a resolution.
Lawsuit kindly taking on Monday.
Yes, yes.
Today I have not come.
Very well. In any event, none is appearing for the respondent also. You have served copy?
Yes, yes.
File that affidavit of service.
Yes, yes.
Affidavit of service filed to be kept on record. Since none appears for the respondent at the time of call, as well as on the prayer of learned counsel for the petitioners, let the matter stand adjourned till April 6, 2026. Yes.
The KMD.
KMD.
Led by
Yes.
the Learned Advocate General is leading.
No. What is the application about?
But the application is the application for stay of operation of the
impugned order.
Impugned order. That is the application. Appeal has
Is
not
the
been
judgment impugned judgment?
by the impugned that I just tell your worship in that
It takes some
nutshell,
time.
Milord. But what we were the allottees of Milord a plot of land. We were in possession. We were asked to Milord do the construction and Milord set up an industry.
Allottees means
but
by the government.
By the government, by the aegis of the respondents. We were in possession. We were supposed to complete the construction and the project within a particular timeline. That has been extended multiple times thereafter. Now, Milord, we were asked that you develop the respondent. Okay, the municipality asked us that you file a supplementary, file a plan.
The KMDA said.
KMDA said you supply, you give a development plan. For that, I have to take the KMC sanction. Now, KMC tells me that unless they give you a registered lease, the KMDA gives you a registered lease, we can't give you any plan.
Catch 22 situation.
So now I am running between these two. In the meantime, probably because there was a policy change, and according to the new policy, this kind of a project ought to be completed within a particular period. That period expired, they terminated the lease. Not the lease, but they basically asked me to vacate. Now, challenging that, we filed a writ petition saying 2 grounds. One, your ground of termination cannot be based on a policy which came subsequently. When the allotment was issued in my favor, this policy was not enforced. That was my first ground. Second ground is that after in a writ petition, they take this point of the policy change in the written in the affidavit in opposition. So that was first ground. The point number 2 was that I have made the entire payment of 5 crore to them. That was the only ground under which that allotment could be cancelled, according to the conditions.
There was no time stipulation in original.
No. Originally there was no time stipulation. So we
regarding development.
There was a no. Originally there was a time stipulation that was extended multiple times. So once time is extended, then that was the third point that.
But there has to be limit to everything. The last extension must have expired.
Before the expiry, they terminated. That's the facts. I'll show you lots. Before expiry, they terminated.
Before expiry of the last extension, they terminated.
Yes, because
they sound of their new policy.
New policy is not written in the termination.
Oh.
That's
So in the writ petition, that is discussable.
Yes, in the affidavit opposition, that ground is taken. New policy is that you are delaying. Now delaying, I have in the last communication, I have shown that I have given a plan, development plan, site plan I've given. They did not consider it. They terminated the policy. The final ground that we took is that the only ground in which the allotment could be cancelled is that default in making payment. I have not only made that payment of entire money, I have paid additional sum because there was a change of nomination. That money also entirely has been paid to them. So after they terminated the contract, they said, very well, we retain the money, you get it back. They offered a check. So we did not take it. It's still with them. Now, Milord, at that juncture, the writ petition was filed. The writ petition was heard on affidavits. Finally, by the order impugned, the writ petition has been dismissed on the ground that Milord, it was a permissive possession. And once it is a permissive possession, no right can be claimed in the land.
and therefore your writ is not maintainable. That is the outcome of the writ petition. This is the nutshell of the
So what is your answer to the permissive
we have two answers, my lord. One is that in respect of a case of permissive possession, my lord, once my lord, it is coupled with interest.
202.
Yes. So, and here my lord, I am asked to do something, and I am taking.
And you have done that.
I have. Of course,
you have
my lord,
invested something.
Yes, I have invested. I have made a plan. I have given the plan. Now, plan has not been my lord, considered.
Is it also there?
But he is my leader. I am being leader. I didn't know.
Yes.
My lord, let me give a little taken aback because my lord, let me give the background. Question is here, my lord. I was allotted a plot of land.
This is that it has been given by your learned friend by saying that you have been allotted a plot of land. The only clause under which you could be terminated as per that was a payment of a quantum which you have paid. The other aspect is that there was a delay on your part because KMC was showing you that KMC was asking something which they did not give you, and vice versa. KMC asked for a lease deed and they asked for a permission from the KMC, which was not given because of non-existence of lease deed. So this was the ground. And in affidavit in opposition to writ petition, they introduced some new policy change, which first of all was not there at the inception of at the time of termination, Mohinder Singh Gill probably. And secondly, that could not have been taken into consideration even otherwise.
Yes, that could not have been the basis of termination because their only case of termination was that circular. And my lord, if your lordship sees the dates, my lord, once I take you to the details, your lordship will find that the time for completion of the project, time was never the essence because it stood extended from time to
that too. That was also
yeah. And ultimately, my lord, when the last date, when was the terminal date, my lord, had not yet arrived before which it was terminated.
That also we asked your learned friend that you cannot eternally go on, but he said that before the last date of
yes,
the extended
which was
time,
fixed, Parties had fixed the time. So before that, all they wanted is, my lord, that you get this sanction done within a month. Suppose, my lord, I had 9 months. He said, do it within 3 months. Now I couldn't do it in the 3rd month. Therefore, on the 4th month, he cancelled it. Whereas my time to construct ultimately was 9 months. So that was, my lord, the event.
the first phase was not done by you. Something.
My lord, the thing is, everything was set up. Our contention is, my client's contention is that for the purpose of getting a sanction plan, we have to show that we have an interest in the land. Because otherwise, we don't know sanction. The interest in the land was a lease. That lease was never executed in our favor. So therefore, the termination was wrong. The learned judge proceeded on the basis that you are only an allottee. And being an allottee, you are basically a licensee. Now, my lord, even if I'm a licensee, once I pay the consideration, it gets coupled with an interest in
202 and all coming. Yes.
Those aspects the learned judge didn't go into.
So there should be stay, Mr. Odigari. Mr. Tarun, sorry. There should be stay.
Let him satisfy me, Lord.
Let there be stay. We cannot hear out the appeal in the present.
There are things, my lord. Here, this is not only the issue.
We'll keep the appeal for hearing on some date. Not some date. You cannot do it before monthly list of May. Because April, as we told your learned friend, I will not be there for 2 weeks. God bless. So we cannot reach it even. Monthly list of May, we are putting the appeal for hearing. Let there be stay till, say, till June 30 or until further order, so that there is a handle for you to come when they'll ask for extension.
The limited period.
Limited period, not till disposal of the.
Meanwhile, could they prepare paperwork?
Yes, we'll give that. Those directions we'll give. Informal paperbooks they'll give and give a copy to you.
There are certain issues to be considered by your lordship.
Like you just indicate, you can indicate. What are the issues?
Here,
in a nutshell, Mr. Taruk, just in a nutshell. Now, we'll only say that these arguable questions have been raised. We will not go into your condition.
Very well.
The present appeal has been preferred against an order passed by the learned single judge upholding your lease deed was not terminated.
Not lease. No lease or license.
I'm sorry, it was never
Allotment letter.
upheld the decision of the respondent KMDA to cancel the allotment of the subject plot in favor of the writ petitioners. Puts up next para. Learned senior counsel appearing for the petitioners, appellants contends that the delay occasioned by the writ petitioners, comma, if any, comma, which was one of the grounds of such cancellation, comma, was due to non-execution of any lease deed in favor of the writ petitioners by the KMDA, comma, which was insisted upon for grant of necessary permission by the KMC. Which of secondly, comma, it is contended that the only ground on which the termination could be effected in terms of the initial agreement between the parties was non-payment of a sum of money which was duly paid by the writ petitioners. Thirdly, comma, in view of the time initially agreed upon for conclusion of the development work by the writ petitioners having been extended from time to time, comma, time was never the essence of the contract. The termination, comma, it is contended, comma, was effected even before the last extended date. Next para. Moreover, comma, it is argued that the KMD relied on a purported circular initiating a fresh policy of the KMDA as a ground of such cancellation of allotment, comma, which introduced a time limit for completion of development work, comma, which was not in force at the juncture when the parties entered into their agreement and as such could not be taken into account at all. Next para, it is also submitted that the learned single judge proceeded on the premise that the writ petitioners were mere allottees, comma, standing in the capacity of permissive occupiers. However, comma, the aspect of acquisition of rights in terms of section 202 of the Contract Act was not considered. For the next para, learned counsel appearing for the respondent KMDA controverts all submissions and seeks to make arguments on merits of the case. However, comma, upon hearing learned counsel, we are prima facie satisfied that a sufficient prima facie case has been made out for the purpose of grant of stay of operation of the impugned judgment. As well as the judgment impugned in the writ petition. Accordingly, comma, there shall be stay of operation of the impugned judgment dated November 2, 2023, passed in WPA 1429 of 2008, as well as of the order of termination of the allotment in favor of the writ petitioners, comma, which was challenged in the said writ petition, comma, till June 30, 2026 or until further order, whichever is earlier. The appellant shall prepare and file the requisite number of informal paper books within 4 weeks from date and circulate copies of the same on the respondents through their learned advocates. Next para, the appeal will be listed for hearing in the monthly list of May 2026. Since we have not invited affidavits in respect of the stay application, it is deemed that none of the allegations made therein are admitted by any of the respondents.
Stay is disposed of.
Dispose of? Can 1 of 2024 is accordingly disposed of in terms of the above observations.
Obliged.
Bar Association program.
I left.
It has started at 4.
I left.